with that, let's get back into the public comment. We're a little bit behind, obviously, and we need to catch up a bit. So let's try and keep to the highlights on the public comments. We're going to have an opportunity certainly to look at this bill one more time. I think we'll be carrying this through and continue to revise it, refine it to the next committee meeting. So we'll have another opportunity to weigh in. But with that, let's go to the other public comment that we have. Next on my list would be Mr. Christopher Allen. If you had any other comments, you've already weighed in, but the broader comments, Mr. Allen, we're interested in hearing any other considerations. And thank you again for your work on the Dow Working Group. Please introduce yourself once again, and the floor is yours.
Yes, Mr. Chairman, distinguished select committee members. Thank you. My name is Christopher Allen, and I'm the Executive Director of Blockchain Commons, a not-for-profit benefit corporation based in Wyoming to support open infrastructure for blockchain and digital identity technologists. As a technologist and a longtime supporter of Wyoming's commitment to blockchain technologies, I feel my particular role in regards to these DAO amendments is to focus my analysis of them from the technical perspective, rather than a purely legal perspective. So, there were some things in the last morning session, whether or not we were getting a little too technical there, and I respect that. In general, I support these amendments as I believe that they support decentralization by helping protect against specific vendor or platform lock-ins that might be implied by earlier drafts. And in particular, I think that they do allow for Bitcoin-based or UTXO blockchains or other future blockchains as they emerge to create membership DAOs, in addition to the sort of Ethereum-based ones that are the primary consideration for the DAO laws. I've also been looking at them from the perspective of future-proofing them against changes in technologies. And I guess my key question there is in regards to the section about governance by the majority of assets or a majority of members. Though I agree that the old quorum language is removing it is good, I think there's still a number of uses for DAOs that are to serve and protect a common or public good, not solely the financial interest of its members or one member, one vote. Many DAOs wish to have governance that might include minority rights or require supermajorities. Currently, LLCs are able to consider more than the interest of the members. For instance, in the past, LLCs have been used to protect historical properties or things that are generational. As a non-lawyer, these options probably are covered, but I really would like the legal experts here as they're reviewing the final draft of this to really be sure that these features of being able to have some flexibility as to who they're serving and how they're serving be available for DAOs. I mentioned my reservations regarding the definition of control. I hope that you're able to clarify that. Not specific to the bill as it's currently drafted, I was asked last year about the requirements for the public identifier that is registered by the Secretary of State. I suggest that you leverage the international standard, the W3C decentralized identifier, as it is being adopted by US Homeland Security and a number of other parties for these types of purposes. In addition, if you are to put some requirements about the principle, about the public identifier, I would suggest that you require the Secretary of State to be careful and not lock themselves into a single DID method or a single blockchain or whatever. And also maybe in their own efforts not to source this technology from a single company or a single platform. As far as which DIDs to accept, there exists a W3C note that has a rubric for evaluating various DID methods, and I would start with a small list of 3 or 4. In particular, obviously, the DID Ethereum contract would be DID, I forgot what the exact middle part, Ethereum something, and then would just simply have the contract address. That should be sufficient for the short term. I really do also want to make sure that there's an opportunity to leverage the Chancery Court on things like forced dissolution and other matters, as I believe that they're going to have special expertise in this. It's why they were formed. And I really don't believe the Secretary of State's office is yet prepared to do some of the types of things that might be required there. I also believe that there are some long-term opportunities with the Secretary of State, for instance, things like cryptographic oracles and things of that nature that could trigger the first steps toward dissolution or other things, but I would save that for a future bill. Finally, separate from approving these amendments, I urge you to put on your agenda to resolve how DAOs can have synergy with your series corporation statutes. Many useful DAO governance architectures are enabled if we can support a series DAO. And I think there's some real advantages for that, especially in the conversation we kind of had at the end of the last session about, you know, who has the principal authority and nested DAOs and things of that nature. Could be that the straight up DAO law as amended here is not intended for those purposes. And it's the framework of a future series DAO that would address some of those complexities. So thank you very much for your support for decentralized autonomous organizations this year. I believe that they demonstrate Wyoming's leadership and will offer very important opportunities for the Wyoming economy. It's been an honor to be part of your efforts. Thank you.
Well, thank you, Mr. Allen. Appreciate that. Any questions for Mr. Allen this time? Thank you. And the series now, you know, I think we need to put that on our work queue as a task of contemplating a series DAO and how to integrate those two concepts. So that's work, in my opinion, for the working group to begin to explore. It's an excellent point that I don't think we've fully accomplished yet. And you know, Mr. Allen, one of the other concepts that over the last couple of years that I think you've raised is the idea of ensuring that we do have compliance with a broader series of blockchains and that we're a little bit more neutral on that. It sounds like you believe that this draft moves us in that direction. Is that accurate?
That is correct.
That's good to hear. And the other concern that I recall was some interest in the manager-managed versus member-managed approach. And so I guess I'd get your input while we've got you on the conversation we had a short time ago about abstracting from a member-managed to a manager-managed by delegation authority, which seems to be allowed for in the current construct of the legislation.
Yeah, I mean, again, not from a legal basis, but from a technical basis, you can delegate a lot of different kinds of authority within smart contracts to specific situations. You can grant them to other algorithmic smart contracts. You can delegate them to individuals, and you can also delegate them to oracles. Like I said, you could, in theory, stand up an oracle about the status of an organization, and with the posting of a bond or some authority of the Secretary of State or some other party, basically notify all the parties that there is a risk of dissolution unless these things are resolved. That's a kind of delegation, a cryptographic delegation that we don't want to preclude, that I think is less than a true manager-managed LLC. So they're kind of, to me, they more fall under, the member-managed who has delegated specific things, as opposed to, hey, I don't want to deal with it at all. You guys handle it, which I think is a different. When you basically give it all to them, I think that's more in the manager managed, at least from the technical perspective. I can't speak to the legal's perspective.
Thank you, Mr. Allen. Appreciate it. Any other questions? Seeing none. Thank you. We'll see you shortly. All right.
I have a small comment.
Let's see. Is that you, Brendan?
Yes, it is.
Okay, Brendan. Yeah, I was going to go to you next. Mr. Brendan Marr, introduce yourself once again, and let's hear your comment. Again, a member of the DAO working group. We appreciate your efforts.
Yes, thank you very much. My name is Brendan Marr. I'm a computer scientist and MIT Media Laboratory alumnus. And my very specific comment here is to embellish on what Christopher Allen was saying in terms of delegation. You can imagine that these have dynamic delegation where under certain events, external events, delegation is pushed off to auditors, et cetera, et cetera. So there's some very interesting things that can be done here, and we will need to explore these, I believe, further. That's all I have to say.
Excellent. Thank you, Mr. Barr. Yeah, again, I think we just need to put that as a task for the working group to really think that through as well. So let's make sure that we've got that in our work queue. Thank you. Up next, I see Dazza up there. Dazza, are you out there?
Yes, sir.
All right, welcome again. Daz Greenwood is a member of our DAO working group. Any comments on this draft you want to share at this time, sir? Oh, and introduce yourself, please.
Yes. Hi, I'm Daza Greenwood, and well, I should probably put my new hat on with my actual thing from law.mit.edu, and and my comments on this draft are that I see that there is a proposal to include that the DAO be under the control of at least one natural person. I heard a little bit of the debate earlier today on how to frame that, and just in general, I just want to stress the importance of ensuring natural human, in the loop and in a authoritative position with respect to material decisions and operations of the entity, at least at this point in time. Thank you.
Thanks, Des. And you were one of the advocates, certainly, for us including that language. Do you feel that language is sufficient as drafted, or something that we need to work on further?
Would you please forgive me to ask, what's the current state of the language? Has it evolved since what was circulated a few days ago?
Des, it should be exactly what was circulated a few days ago, what you've seen.
Oh, well, my hot take was that it was good enough because it said the words, and you can always get more detailed. There's a risk in getting more detailed, but I think it puts the concept across. So I thought it was sufficient. The only, I guess, if there's one thing on my mind, from last hearing, there was some back and forth over how would the Secretary of State become aware that a DAO was no longer under the control of at least one natural human. And I had emailed you, Senator Rothfuss, and some other people with one possible idea. I'll just mention it now, which is that it seems as though there's guidance from the Secretary of State in Wyoming to the effect that the registered agent, beyond just transmitting things like, that the company's being sued and that kind of thing, also goes a little deeper in terms of maintaining contact information of people responsible for the company. I sent you a link to some of the guidance from the Secretary of State on how they're interpreting the duties and role of the authorized agent. I just want to throw out there that one possible mechanism could also be to authorize the registered agent, or even to require them to communicate to the Secretary of State if they should become aware that the DAOs that they are the agents of no longer have a human in control, and maybe even to vest them with some responsibility to check from time to time, like with their contacts, that kind of thing.
Interesting. Thank you, Dazza. Any questions for Dazza? And Dazza, you might not have been here for the earlier discussion. The new language at the bottom of page 10, the paragraph C says any interested party may petition the Secretary of State alleging the existence. So we have that. We had a discussion about the Secretary of State's office had a concern that maybe they weren't the entity to be petitioned, and perhaps it should be done through district court and or the chancery court, so that you have a finding of fact associated with that petition. I think that's kind of where we're leaning now. The idea of incorporating the registered agent in some way is something new that we haven't discussed. But do you have any thoughts on that C paragraph, meeting that interest of providing the petitioner, which again was something we discussed last time that I think you were one of those that raised and supported.
Yes, sir. The basic thought was, it seemed like some reasonable escalation path would be useful, but before you go right to a court or a Secretary of State and commence a dissolution action. That's kind of the death penalty for these entities, and it might be good just to check, that the human in charge hasn't changed, or maybe wasn't on vacation or something like that. And so if there's just some way to leverage that registered agent, I think it might be good, maybe as a first step. And then if you want to really push it, you could look at the law creating the role of the registered agent and see if you could add a duty that would, when they are the agent of one of these DAOs, that at least once every so often, what a year or a quarter, they confirm that there's at least one human in control of the DAO. And if they're unable to do that, that they then escalate themselves and then to wherever that is, the court or whomever you decide. And then likewise, if someone believes that the DAO is no longer under the control of at least one natural person, the first stop should be the registered agent to check. And it occurs to me, while that is more of a duty and it's not the customary role of a registered agent, these DAOs are not customary entities either when they're algorithmically managed. And maybe it would be a cool thing in terms of another line of revenue or another fee or another way that these this role of this state authorized character of the registered agent could actually carry more weight within Wyoming and bring more muscle and revenue to Wyoming.
Good, thanks, Deza. Committee, any thoughts or comments? I see you, Christopher. I'll come back in a second.
Yes, thank you. I did want to say that changes to how registered agents work and the possibility of a new form of a digital registered agent, digital commercial registered agent, or something of that nature is part of the e-residency discussion that I hope we'll be able to get to later.
Thank you, Mr. Allen. Mr. Mara? You're muted. There you go.
Yes, I concur with Christopher Allen, and I was going to say the same. Pretty much that's one of the roles that an e-residency could perform, and we'll talk more about that later.
Great, thank you. Any other questions for? Great. All right, seeing none, thank you. Appreciate that input. And let's see, do we have Professor Hughes online at this time? I see her on my list. Okay, excellent. Thank you very much. All right, that concludes my list. Do we have anyone else online? We don't. All right, then let's open it up to public comment in the room on DAOs. Anyone like to provide public comment at this time on this DAO draft of legislation? Please come on up and join us. And once again, introduce yourself. Welcome.
Hi, I'm Jade from Silicon Prairie Holdings, primarily a technologist, gave some other comments before. So I'm also coming at it from a technologist perspective. I think it's pretty critical to remember that regular entities can be regulated by multiple government agencies. And so anytime that you can have something that says shall versus must, that leaves space for entities that have a lot of daddies, essentially. One of the things to remember, I liked, and I wanted to agree with that, considering that language of asset, because not every smart contract has or needs a coin. So that's pretty critical from our perspective. And I think that kind of consideration of, should there be a natural person who has essentially a license to kill, versus you may also want to consider, should there be a dead man switch or a sundown? And then the ability to have a nested DAO with the ability to delegate, I think is kind of critical. We have a lot of different regulated entities, so they all have different regulators over them. But the transfer agent division specifically handles voting. And there can, of course, be a reason why you would have to recuse yourself from a vote. So you could have multiple DAOs that overlap each other and have some reason why one should not have an interaction on another. For example, we have a document automation stack, Geppetto, and we're in the process of harmonizing compliance across multiple regulated entities. That doesn't rise to the level of something that would be officially a DAO in Wyoming, but it is literally distributed automation. And so we're hyper aware of the ability to either have proxies or occasionally need to recuse yourself.
So thank you.
That's all I had. Thank you.
Any questions? Questions, committee? Thank you very much. Appreciate the presentation. Any further public comment on the DAO legislation this time? If not, public comment is closed. Back to the committee. What are your thoughts on how to proceed? It seems like we've got some ideas that we'd like to incorporate. I think the bill draft's in good shape overall, but maybe some tweaks. What are your thoughts at this time?
Mr. Chairman, I think at this point, I'm comfortable based on the testimony we've heard pretty straightforward that we've accomplished today. The concepts that have been tossed around that I'm not sure we're ready to propose language today. So happy to follow your lead on this if you want to talk about those changes today and get those in the bill draft and push everything else forward, whatever you prefer.
Well, I think it would be best, and see if anyone disagrees on the committee, that we proceed with the ones that seem to have general consensus, the three that you discussed, which I suspect are probably the same three that I've got listed. We can raise those, work them, incorporate them into bill draft for next meeting, but then also do some more review and discussion on the working group to try and figure out if there are any other nuanced changes that we should be looking at. Does that seem reasonable? Yeah. Okay. All right, Mr. Kaufman, you want to walk us through the three you see as being a priority?
Yeah, I think the first one is maybe the one we developed the most today, Mr. Chairman, was this idea of removing the actions for dissolution from Secretary of State's office to Chancery Court, at least to a court. Yeah, and not within the Secretary of State's office. And just to add a little flesh to that, Mr. Chairman, you mentioned earlier some reluctance about specifying Chancery Court because of the filing fee. The only pushback I would have on that is probably if we're going to designate district court, we don't also want to gum up the district courts with a bunch of actions over fractional interest in a DAO either. So maybe that $1,000 filing fee creates a little bit of a threshold for which, if the dispute's not worth enough, I don't see what I'm getting at, but and maybe that's not the right way to be looking at this. But some of these DAOs, at least a few that I've been working on already, fractional interests are very small. So I don't think we want to inadvertently allow somebody's remedy to skip over what otherwise would be circuit court jurisdiction and go straight to district court with a relief. Maybe the same could be said for Chancery Court as well, but.
Go ahead, Representative.
On that issue, I'd be in favor of investing exclusive jurisdiction in the Chancery Court to petitions to dissolve, because it would create a barrier to entry. You want a barrier to entry because it's the death penalty for the company. It's a really serious thing. You don't want someone who's just unhappy about the way it's being managed to pay the $110 filing fee for district court and threaten the existence of the company. So I think having the exclusive jurisdiction of Chancery Court limited to that equitable remedy would be appropriate and constitutional and make a lot of sense.
Other thoughts, please? Go ahead.
Yeah, I think my preference would be for either court. I would say that to Representative Smith's point, if you want to make it so it's easier to make sure that all voices are heard, maybe the best process wouldn't be a court that would be designed to move things faster along on dissolving a DAO LLC. So I don't know if only the Chancery Court is the right answer, or only district court is the right answer. I mean, I'd be in favor of both, but I do think either makes more sense than the Secretary of State.
Senator Nethercott, thoughts?
Thank you, Mr. Chairman. I think it is unwise for the statute to determine which court the litigants choose to avail themselves of for an appropriate remedy for a variety of reasons associated with jurisdictional and threshold requirements, needs of the litigants and the parties and locations thereof. So like all other matters, with just broad prohibitions associated with jurisdiction, I think we leave that to the discretion of the litigants, the courts in which they may file. Certainly, I support moving Secretary of State's to a court of competent jurisdiction should be the language. So a court of competent jurisdiction as opposed to Secretary of State's office. Beyond that, leave it up to the litigants in the true spirit of our libertarian ways.
Does anyone have any concern? I think that probably gets at the heart of the discussion. I hope it always ends up in a chancery court, but court of competent jurisdiction where we don't predispose. I think that's my inclination.
Mr. Co-Chair.
Go ahead.
Other than two representatives, it's point death penalty. Which we all know how I feel about that.
Right there with it.
$150 filing fee to get access to the district court, $1,000 filing fee. So how much do I really care about this now? And then the organization or whomever is going to have to defend it in court to say whether it should be dissolved or not. So it could become costly endeavor. And I think representatives at this point is trying to filter some of those people out who don't have legitimate claims. And I have to fight that in district court on an expensive motion to dismiss or motions for judgment and I spend thousands of dollars defending that, whereas when someone spent $150 threw together, pretty basic complaint just to get me in there. So I think I don't know where I land on exclusive jurisdiction, but I think I know this for certain. I agree with taking it out of the Secretary of State's office. That is a bureaucratic burden and expense that we don't want to deal with trying to fund. The court's the best place to dispose of it. I think the $1,000 is a good way to balance it. And Senator Nethercott can better articulate how we're going to keep the not legitimate litigants out of district court and fund the docket.
Senator, go ahead.
I mean, access to the courts is a fundamental right and a constitutional right. We're not here to predetermine the quality of that dispute. The courts are suited for that, and they can. And filing a lawsuit, as frivolous as we allege they may be done, actually it's not easily done. It requires some effort. So if you want to attach a special filing fee, and you think that is the closed door to accessing the courts, it's a different conversation.
Go ahead.
Mr. Chairman, perhaps the more important argument is the delay and the time associated with district court. Chancery court moves fast. You get things wrapped up in 6 months. And if you've got a threat that your organization is going to get killed, you want that threat resolved quickly one way or the other. Whereas in district court, we all know what that's like. I filed a motion at the end of July. I was very surprised to get an order within just 7 weeks. But the order, instead of deciding the motion, said that the court would decide whether it's going to decide the motion sometime in December.
Mr. Just a couple of thoughts. I mean, one, there might be a way to split this because we're talking about two different changes here on page 10 in subsection, let's see, 5. It says by order of the Secretary of State. So we're talking about after one of these conditions for mandatory dissolution has been met, we put that burden on the Secretary of State's office. I think as a suggestion, that change could just say any court, right? We don't have to specify Chancery Court. Any court could order this entity to be dissolved. So that's that issue. And secondly, we were talking about who can petition. And the language right now says any interested party can petition. If you're an interested party and you want to claim that one of these dissolution effects has been met, to me, that's different than a fundamental right of litigation, and we should push that to a higher standard where Chancery Court makes a lot of sense, because again, we might be dealing, it's almost like an involuntary bankruptcy petition. And anyone can file that against a company at any time in federal court and try to take a creditor's claim action. It's almost the same type of remedy where you're saying, I deal with that DAO, or maybe I used to be a member of that DAO. I think they meet the criteria for mandatory dissolution. I'm going to bring that action. And I would advocate that it should have a little bit of a higher threshold. Chancery Court makes a lot of sense for that. So I just wanted to make the distinction that we could have both options. And again, we're not talking about the rights and remedies of anybody and members. If we're talking about fiduciary obligations, breach of contract obligations, I think Senator Nethercott's right. They can choose, the litigants can choose their forum for that. This is only limited to that interested party being able to apply for dissolution.
Representative Yin?
Mr. Chairman, so maybe this is a question for LSO, but are there any places in our corporation statutes where we designate the Chancery Court as a specific court that has to hear certain things? And if not, why would we make this the precedent for that?
Any thoughts?
So that the second part of the question was to the committee, but the first part of the question was to LSO.
There's no current statute that designates the Chancery Court as having exclusive jurisdiction. That would be
Any thoughts? So interested party. If the concept originally, which is justification for the Chancery Court, was that there'd be nuisance lawsuits filed, and then kind of a justification here is the fact that interested party creates a limited subset of potential litigants. In this case, that sort of obviates the nuisance lawsuit filed by somebody walking down the street and creating this undue burden. So I guess I'm not compelled that we need to get to the Chancery Court at that point as the only remedy. Although again, I would expect it. To Representative Smith's point about the fact that the Chancery Court is going to have the immediacy that's needed and make the resolution much quicker. If it's a court of competent jurisdiction and there's a desire to move to the Chancery Court, it would be moved to the Chancery Court based on the construct that we had for the Chancery Court. So I think that request can be made. Can that be made unilaterally though? I don't recall how we structured that. If I'm one party in litigation and I want it to go to Chancery, or do I have to have agreement between the two parties? Go ahead.
Mr. Chairman, that is a complexity here because our Chancery Court rules state that if you request a jury, then you're automatically kicked into district court. And so we would need to think about that here. If somebody filed a petition in Chancery Court and Chancery Court was the mandatory jurisdiction, what if somebody requested a jury?
Yeah, I don't know into that. Go ahead.
Move this along. Why don't we ask LSO to make it a court of competent jurisdiction? Right? Do that. That way we don't spend all day on this. And frankly, in your smart contracts, you can say everyone agrees to its Chancery Court.
Absolutely. All right. Sounds like a motion, and I heard a second here whispered to me. Anyone oppose that approach? Seeing none, all those in favor say aye.
Aye.
Opposed, no. All right. So that's the approach. Court of competent jurisdiction can be applied to, and we'll draft language accordingly. Mr. Hopkins.
Clarify, Mr. Chairman, was that only applying to paragraph 5, where we were changing that language for competent jurisdiction, or was it a broader amendment?
It's
the C as well.
It's the C. The C paragraph of any interested party and their appeal is currently drafted as going to the Secretary of State, but instead it would be going to any court of competent jurisdiction to make that decision. And so we'll take a look at that. There was discussion on this point about something with the registered agent trying to find a less death penalty approach, I think is the idea, something intermediary. Let's explore that and talk about it on the working group and see if we can find a remedy. I don't know exactly how we draft that. Is that fair? Okay. All right, next point.
Mr. Chairman, the second one that we talked about was on pages 5 and 6, and LSO had prepared a couple of different versions of subparagraph D, and then a third alternative, which was that new 1731-109. And so obviously the committee needs to make some selection on which choice is best.
Is there any objection, and I'll just see if there's any objection to going with the choice of the new language 1731-109, bottom of page 7. Bottom of page 7, I think it is, right? Transitioning onto 8. Nope, I'm sorry. That's page 6, top of page 6. 1731-109, the new language. Any concerns about that? All right, seeing none, let's move that forward as the choice. So it's choice 3 under management, and that would include the elimination, I believe, of paragraph D. Double check that doesn't break anything, but that's what we'll go with. Ms. Kaufman, back to you, third idea.
The last one was the very first thing we talked about today, and that was this issue where right now, although I agree with the comments that we heard that we don't want to have a specific public identifier format that we're necessarily selecting right now. And that's the feedback we've received from the Secretary of State's office, is that's going to be hard for them to police. But what the Secretary of State is seeing is people filing with just a to be determined or something to that effect. And so the suggestion would be in 1731-105, the simple addition of language that if a valid public identifier isn't added within 30 days or some prescribed time frame, then the filing is void.
If we're comfortable having that draft inserted, timeline 30 days seems reasonable. If you can't provide your digital identity in 30 days, your identifier. All right, everyone's nodding. Any objection to it? Seeing none, let's proceed with the addition of the language to provide 30-day compliance on the unique identifier. And again, not being specific on what that format is with W3C standards, but we can talk about that later. All right, we're okay on that. Was there anything else, Mr. Kaufman, that we want to do for the next draft?
That was my list, Mr. Chairman.
Okay. Committee, was there anything else that we heard today that we want to include in the next draft? We can talk about a lot of other things and work them through the working group and try and raise any other concerns that were discussed, but those seem like 3 that are solid right now. All right, seeing no further suggestions, any further final comments before we table this till the next meeting? All right, seeing none, let's table that to the next meeting, get the revised draft for next meeting, and then the sooner we can get that organized, we'll get it to the working group, we'll get additional review, and we'll have some conversations perhaps about some of these other points. All right, excellent. Thanks, everyone. You want to do e-residence now, or do you want to carry on, try and get the schedule and do e-residence again? We've got chance reports now.
Answer report sections.
I think digital identity and e-residence go together well. Probably do it. Okay. All right, let's move to the Wyoming Chancery Court update. Maybe that'll help us get back close to schedule. We'll see though. I think it will be relatively quick, but we'll bring Mr. Birmingham to counsel of the Chancery Court up to provide us with an update of where we're at. We appreciate the work that you've done. Please introduce yourself to the committee. I think this is the first time you've been before us, if I'm not mistaken. So welcome, and appreciate the work that you've been doing.
Thank you, Mr. Chairman and members of the committee. My name is Ben Birmingham. I am the Chief Counsel and Director of Wyoming's new Chancery Court. I appreciate you giving me some time today to provide you with a brief update on Wyoming's Chancery Court. I want to start by just quickly giving my introduction, context, and some relevance. So I've heard in these meetings some expressions of concern about Wyoming potentially losing its first mover advantage in this space. I recently read an article that's forthcoming in the Fordham Journal of Corporate Law and Finance that recognizes the same concern. Wyoming's put in all this work to establish this cutting-edge legal framework, but it's easy for another jurisdiction to come copy that work and adopt it as its own. But the article points to Wyoming's Chancery Court and notes that a specialized court with judges who have experience in these cutting-edge issues and who can build up a body of instructive case law, that's much more difficult to replicate. And the Chancery Court in this way can help complement the work of this committee, and it can help preserve Wyoming's first mover advantage. So with that brief context, let me just quickly answer the basic questions you may have about Wyoming's Chancery Court, starting with what is the Chancery Court? So the Chancery Court is a specialized court of limited jurisdiction that will resolve business and trust cases on an expedited basis without jury trials and with limited motions practice. And in creating a Chancery Court, Wyoming is not creating new ground here. It's actually joined a much larger modern business court movement. There are at least 25 states that have some form of a specialized commercial court. And there's great variety in terms of the jurisdictional scope and the core practices of these courts, but they all share the common characteristic of specialization. That is a judge or set of judges that gain experience and specialization in business and trust law, and with specialization can provide quicker results and more uniform results. And that's really explains why a Chancery Court, why have a Chancery Court. It's because the specialization leads to consistent case management. It builds up a body of reliable case law that companies can look to guide their practices. But its benefits have the potential to extend beyond the business community and commercial litigators to the entire judicial system. So the theory is that the Chancery Court can remove some of the more time-consuming, complicated commercial cases from the general dockets and allow district courts to focus and have a little bit more time to work those really important criminal, civil, juvenile, family cases. And it also can benefit the judicial system by serving as a laboratory of innovative case management practices. So Wyoming's Chancery Court will pioneer e-filing. It'll be the first state trial court to use e-filing. It'll be mandatory from day one. And it also hopes to test out some new case management practices that will help us expedite discovery. And in the end, it should attract and retain businesses. So let's get to the question of when will the Chancery Court be open for business? In 70 days. So on December 1st, 2021, the Chancery Court will open its virtual doors and start accepting cases. And to prepare us to open in just a little over 2 months, we are finalizing the Chancery Court rules. Those should be finalized any day now. And we're preparing that e-filing system so that it will be ready for prime time. Of course, to open its doors, the Chancery Court needs judges. And a full-time Chancery Court judge has not yet been installed. So 3 district court judges with experience in business and trust cases, Judge Fenn in Sheridan, Judge Lavery in Green River, and Judge Sharp in Cheyenne will handle Chancery Court cases until a full-time judge is appointed sometime in 2023 with the fully staffed chambers. And the new Chancery Court will have use of a brand new courtroom and chamber that are under construction as part of the Casper State Office Building. This space won't be used until a full-time judge is installed. For now, the Chancery Court's clerk's office will be in Cheyenne. And with the clerk's office in Cheyenne and 3 judges spread throughout the state, remote proceedings will be especially important for the Chancery Court. So it will use the technology that attorneys, of course, have become very accustomed to during the pandemic. It will use video conference software to conduct a lot of its proceedings. And even when a full-time judge is installed, the Chancery Court hopes to be a modern court that will use technology to increase convenience and minimize costs. As I said, the Chancery Court will use electronic filing from day one. And this will really should promise some efficiencies. Attorneys know that traditional filing involves many steps: drafting a document, printing the document, signing the document, taking it down to the clerk, mailing it, drafting cover letters. E-filing streamline this process by allowing an attorney to sign on to his or her e-filing account online, upload the document, and with a couple of clicks, both file and serve the document. The e-filing service vendor is a company called File and Serve Express, or FSX. This is the same vendor who provides e-filing services to the Delaware Chancery Court, and its experience in a similar court has really proven helpful to the court. Of forced to implement e-filing from day one and to account for its expedited nature and limited jurisdiction, the Chancery Court needs its own set of rules. So the Wyoming Supreme Court is preparing to adopt a final set of rules, and this set of rules will be adopted before October 1st. And the rules, they are a modified version of the rules that apply in typical district court actions. So the rules of civil procedure that typically apply have been revised to account for the fact that the Chancery Court does not have jury trials, that motions practices will be limited, that its jurisdiction is limited, and that it will require electronic filing. Let me quickly touch on the jurisdictional parameters of the Chancery Court. So these, the jurisdiction is set by statute, and the statute limits the court's jurisdiction in three ways. First, the dispute type. So the statute provides that the Chancery Court will resolve commercial, business, trust, and similar disputes. And it further limits the court's jurisdiction to cases that request equitable relief, declaratory relief, and monetary relief that exceeds $50,000 exclusive of costs, fees, interest. And the real big limitation is that the statute sets forth 20 eligible case types. And these are the 20 case types that fit within the court's jurisdiction. So just to give you a flavor of these, involve shareholder derivative actions, uniform commercial code actions, uniform trust code actions, breach of contract actions. The $50,000 monetary threshold does not apply to all of these. It does not apply to dissolution actions, shareholder derivative actions, trademark actions, and certain arbitration actions. The Wyoming Rules of Civil Procedure will explicitly exclude 10 types of actions. These will be included in the final set of rules to be adopted by the court. And to give you a sense of these excluded actions, they include personal injury, consumer claims, worker health and wage claims, most environmental disputes. It's important to note that while the Chancery Court has statewide concurrent jurisdiction over these 20 defined case types, it also has supplemental ancillary jurisdiction. So the jurisdiction of the court has a potential to extend beyond those 20 statutorily defined case types. I think it's also really important to note that the Chancery Court will be a full consent jurisdiction. So that is parties must mutually agree to proceed in Chancery Court. So the rules that will be adopted here soon will give a defendant an opportunity to object to proceeding in Chancery Court. And if the defendant files an objection by the date that the defendant's initial pleading is due, the Chancery Court has no option other than to dismiss the case without prejudice. But if this objection is untimely, then it is waived. And conversely, if parties would like an expedited form of resolution, are not happy with the pace of things at district court, they can jointly move to remove a case from district court to Chancery Court. They have to do so by consenting in writing within 20 days after the last defendant is served. There's been some reference today to the Chancery Court being a streamlined form of resolution, of providing expedited resolutions, and that is the statutory call for the Chancery Court to move things along quickly and to put this into days. The statute gives the Chancery Court the goal of resolving a majority of its actions within 150 days. And most attorneys will tell you that the biggest threat to meeting this statutory objective is discovery and discovery disputes. So to recognizing this threat, the statute, the enabling statute, and the rules of court grant the Chancery Court broad discretion to be active in case management and to shape discovery. So you can, a litigant can expect the Chancery Court judge to be very active, to help manage cases, to snuff out disputes before they really fester in protract litigation. And then litigants can also expect the Chancery Court judges to use informal dispute resolution methods, like requiring the parties to submit short letter briefs rather than extensive briefing and extended argument on discovery issues. You might also expect the court to require the parties to come down, attend an oral conference, and try to resolve disputes short of motions practice. So there's a quick overview of the Chancery Court. The takeaway is we open our doors on December 1st. We'll be using e-filing, and our rules should be in place. So I thank you for giving me just a few minutes of your time to provide you with an introduction to the Chancery Court, give you a status update. I'd be happy to stand for any questions that you might have.
Thank you. Questions? I see Joel at the end. Okay, Ms. Long, go ahead.
Just real quickly, Mr. Chairman, what, you mentioned e-filing is unusual. Are other states courts using e-filing, or are we early even in e-filing nationally?
Go ahead.
Mr. Chairman, Ms. Long, many states use e-filing in their state trial courts. Wyoming has not yet adopted e-filing. I think the benefit of Chancery Court is we can, with the limited caseload, we can really perfect the process and prepare it to be extended.
Good, thanks, Paul.
Thank you, Mr. Chairman. Mr. Birmingham, thank you very much. Excited to get this underway. I don't know if this is an appropriate question to ask now, but my experience is that Delaware is often selected because of the precedent, because of the jurisprudence that exists there. Will Wyoming be adopting any existing precedent to sort of speed that comfort for the attorneys when selecting Wyoming as a legal situs?
Go ahead.
Mr. Chairman, I don't want to speak for the judges who will be resolving these cases. I don't want to get ahead of them, but I don't think it's unreasonable to expect them to look to the persuasive case law by their jurisdictions. And Delaware Chancery Court really is the North Star that many business courts look to. So I think it's reasonable to expect the court to Delaware Chancery Court precedent.
Go ahead, Mr. Chairman, just for Joel's clarification.
When we first started on the path of creating the Chancery Court, we did have, I don't remember if it was an amendment to the original bill or a standalone bill to basically codify all of that common law, which did not prevail as an idea going forward, but the committee did consider to speed up the process to make earlier. At least that was a good idea, Ron. That was at least the idea. We had all of that case law, we had all that precedent. We want to come to this court because this will be here.
Thank you, Mr. Good. Any further follow-up?
I do. Thank you, Mr. Chairman. One other question, and again, I apologize for my lack of knowledge here on how it might typically work, but you described it where a defendant could opt out of Chancery Court. So if in a contract, if a DAO or someone who's acting as a trustee or custodian has in contract all matters will be resolved in the Wyoming Chancery Court, does that not hold then if the defendant says no? Is that, do I understand that correctly?
Bring in.
Mr. Chair, so the rules of civil procedure will give defendants the opportunity to object, and the Chancery Court must dismiss. But I think if parties have a choice of venue forum that selects Delaware Chancery Court, and one party is not following that, then I think that leads to a breach of contract claim that the other party would open itself up to.
Mr. Bill Paul?
I just want to clarify, I heard correctly. So if a contract states that it's the Chancery Court, that supersedes that ability to opt out. Did I understand you correctly just now?
Go ahead, Mr. Kim.
Mr. Chair, again, I don't want to get ahead of the judges who will be deciding these issues, but I'd have to think that the judge would be controlled by the rules that govern the court, and the rules allow a party to object and require the judge to dismiss. So I would think if a party has agreed to a choice of forum clause that designates Delaware Chancery Court as a forum, those parties, despite that clause, objects, and I think the other party would have the opportunity to raise that as a breach of contract in district court.
Senator Medicott, do you have any thoughts on that? Representative Stitt.
Mr. Chairman, are you kidding me? Are you saying that if I have a venue clause, that's not going to be enforceable in Chancery Court? That the proof? Is that what you're saying?
Yeah, thank you, Mr. Chairman. I think as was presented, it was technically accurate as to the legal process associated with the rights for any court. So commonly in most contracts, for any type of subject matter, there is a choice of venue forum that is selected. So, you know, the District Court of Laramie County is common. So if litigation is commenced concerning a dispute around that contract and it's not filed in the Laramie County District Court and the other party objects, unless there's some, you know, bizarre factual basis as to why they would object to what was already agreed to in the contract, the plaintiff would move forward to enforce that contractual provision, to deny the change of venue, and more likely than not, the court would enforce that venue is appropriate within the court as determined by. And the Chancery Court would do the same. There is no difference, but the Chancery Court is still subject to the rules. And a defendant always has the right to object in the rules, regardless of the contract, right? But the contract would still override probably that objection.
Mr. Chairman, just so I understand, so this issue about whether the venue clause is enforceable, in your view, Mr. Bernigan, that would have to be litigated in district court?
Go ahead, Mr. Birmingham.
Mr. Chair, Representative Sept. Again, I don't want to get ahead of the experienced judges who will be addressing these issues. I think that the objection would have to come first, as Senator Nethercott says. And then I think the Chancery Court would have the opportunity to then weigh in and enforce the contract.
Mr. Chairman.
Go ahead.
So procedurally, complaint is filed in Chancery Court. Defendant objects to the jurisdiction or moves to transfer, right? Chancery Court would still have the ability to do that request. The plaintiff's response would be jurisdiction is appropriate for the reasons of the contract.
I just,
Go ahead.
it kind of depends what the rule says. If the rule says that if I object, the court must dismiss, it seems like that rule should have some exception built into it, right? It seems like there's a problem with the rule, if that's what the rule says. That's my point. But beyond our scope today, perhaps.
Go ahead.
Mr. Chairman, I'm so happy for this moment because I can tell everybody that I was the lone vote on the Chancery Court Committee actually for this very issue. The way the rules currently read, Mr. Birmingham, you explained it perfectly correctly. If you file in Chancery Court and the other party objects or files a jury request, it's automatically removed to district court. If you have a provision in your contract that obligates you to Chancery Court, you'll then have to bring that to the court's attention. I think what Mr. Birmingham is eloquently saying here is he doesn't want to speak for the judges. There might be other considerations. There might be invalidity in that contract, but absolutely the parties will be able to try to enforce that. Just like you would if there was an arbitration provision or something, right? People disregard that. You would have to have the court make that determination. But I personally do have a little bit of a problem with the procedural misstep, and that is if somebody files an objection, you're automatically removed. And so there might be a step for the parties to have to, you know, reassert themselves to go back to Chancery Court. But I was the minority on that procedural call.
Senator Nethercott.
Mr. Chairman, thank you. Mr. Kaufman. There is a contract where the parties agree. So your opinion based on the rule, or your legal opinion, your opinion based on the rule, the Chancery Court cannot make a determination as to whether or not to
Mr. Chairman, I'd love to give Mr. Birmingham's take on this. My reading of the rules is that it's automatic. If someone objects or there is a jury request filed, it's automatically removed to district court. And at that point in time, the filing person entity would have to make a motion, presumably for the Chancery Court or for the district court to review that request. And that was the problem that I was trying to fight against was I think that fight should be in Chancery Court, not in district court, but I was outweighed.
Thank you. Any further discussion? All right, we can look into that more. I think that's an interesting little nuance that I suspect that chairman of the Judiciary Committee may contemplate further.
I'm
All
sure
right.
she wants to pass a statute.
Well, go ahead and specify.
Override the approvals.
Override the committee.
All right, further discussion on this? Any further questions for Mr. Birmingham? Seeing none, thank you so very much for the update. We appreciate it. And look forward to December when this all kicks off. Cool. Any public comment on the Chancery Court update? Mr. Marr, we had you down as being potentially interested in weighing in a little bit. Are you still out there?
Yes, I am. Can everyone hear me?
You can.
Yes, once again, briefly, I'm Brendan Marr. I'm a MIT computer scientist, alumnus from MIT. And my comment here is I understand that you are looking towards e-filing, and the questions are, to what extent are you looking at being able to allow for, filing and plugging into to other blockchains and whatnot. I mean, obviously that's premature at this point, but when it gets to the idea of being able to deal with things quickly and expeditiously, I think you'll find our discussion later on in terms of a registered token where contracts and agreements and parties and agents can be pegged to Wyoming jurisdiction quite interesting. So I'll bring that up right now as something to note, which we'll be discussing later. Thank you. That's all I have to say.
Thank you. Appreciate that, Mr. Marr. Thanks for the input. Any questions for Mr. Marr? All right, seeing none. Thank you. Any further public comment at this time? Report update. Seeing none, public comments closed. Back to the committee on Chancery update. Sensing a desire for a motion. Is there one?
Mr. Co-Chair.
Yeah, go ahead. Senator Nethercott, what are your thoughts?
Thank you, Mr. Chairman. In support of our select committee member who was the lone vote, we never like that. When they get overruled, we would like to support his efforts before and override his previous action of being overridden. So I'd like a bill draft that indicates where there is a contract or a choice of forum venue has been determined by the parties to be the Chancery Court. The Chancery Court shall have jurisdiction over that dispute if there's an objection of the removal or findings.
Second. Get a motion in a second. I assume that's pretty well understood, Mr. Hopkinson, what the connotation of that is. Is there any discussion committee on this motion? This is a motion for a bill draft. We would see this bill draft in November for our consideration. So again, you're not voting for it, you're voting for the bill draft. Any discussion on drafting the motion? Go ahead, Mr. Cox.
I fully support of the idea. What I'm questioning though is where to put it, because obviously these are rules of procedure. So
we will sort that out.
We're gonna have some separation of power issues with the court, but
Mr. Chairman,
Go ahead.
Accustomed to those.
I think in Title I, there are some here in between
code of civil procedure.
statutorily set some rules. It's very rare that we do that, but I do recall at some point coming across those. But LSO will figure it out for sure.
That's what they do. All right, further discussion? Seeing none, all those in favor of the motion, say aye.
Aye.
Opposed, no. That motion is carried. Look forward to a bill draft in November. Thank you. Any further discussion on Chancery Court updates? Seeing none, moving on to digital identity, and for the edification of Mr. Christopher Allen and Mr. Marr that are still probably concerned about when we're going to talk about e-residency. I think this is probably an appropriate place for us to address that when we get through the topics we've got. We'll pull up an e-residency discussion prior to the next topic item of non-fungible tokens. Hopefully we'll be able to get through all of this expeditiously. We just have a few quick updates kind of on the direction of what we're discussing on digital identity working group. And we'll hear from some of the working group folks. we have available for testimony. Let's see if there's anything we need to get into before update from the group. Go ahead.
Just confirming. Yeah, correct.
Motions, yeah, we're going to go through general motions and discussion at the end of the session. And I've got a couple as well. Probably need to look at. All right, so on digital identity, part of what we've been looking at, there are some materials that are available where we've provided to see a discussion of CPA, the California Consumer Protection Act summary. We've got some text, and then we'll have a digital identity presentations from Blockchain Commons and Mr. Christopher Allen. So I'll invite Mr. Hopkinson to come up and give us a little bit of an overview of the analysis of the CCPA and other legislation related to consumer protection. One of the things that we have to do with our digital identity framework that we put in place last year is now start fleshing out some of the concepts of the privacy rights, the property rights that are associated with it, recognizing that we have some frameworks that we can work within that other states have passed, like the CCPA in California, and the state of Virginia, state of Colorado have passed legislation. Others are working on legislation. Mr. Hopkinson did an analysis to try and contemplate what is there that we might potentially bring into our digital identity framework and our consumer protection as a basis, and then build off of. So with that, Mr. Hopkinson, if you can kind of do just a brief walkthrough. We don't need a nuanced detail. We've got about 150 pages here since the California Consumer Protection Act, what they've got there. But if you could walk us through some of your findings, that would be great. Thank you.
Mr. Chairman, thank you, David Hopkinson, with the Legislative Service Office, and I'll just kind of briefly cover what, and really I think kind of compare California to Virginia and Colorado, just for the committee's reference there. So essentially the privacy laws that have been enacted are tailored to allow consumers to request personal information that businesses have collected from them and the source of that personal information. They're allowed to request businesses to delete personal information or correct inaccurate information and limit the use of sensitive personal information. And that term is a defined term we'll get to. It allows them to consumer to opt out of their sale of their personal information, require websites to post privacy policies specifying what information is shared with third parties and how consumers can request changes to that information. That's kind of generally what we're dealing with is managing your own personal information and how providing some control to consumers of how businesses are managing that information. California enacted their law became effective January 1st, 2020, with some significant amendments that were subsequently made and that become effective July 1st, 2023. Virginia essentially took a lot of what California did, kind of pared it down a bit, and theirs law becomes effective January 1st, 2023. And then Colorado kind of looked at what Virginia did, pared it down a little bit more, and theirs becomes effective July 1st, 2023. Some of the areas that these cover, and would be, I think, important for the committee to kind of ultimately decide how much coverage they want to provide for this privacy protection. Some of the things, for example, with exemptions, we see some distinctions amongst the laws that the states have passed. California allows for exempts nonprofits from the privacy protection laws. They exempt entities regulated by HIPAA laws. Virginia exempts certain financial institutions subject to certain federal laws. HIPAA companies subject to HIPAA, also nonprofits and institutions of higher education. Colorado is similar to Virginia, except they don't. I don't believe they have that nonprofit exemption. For certain information such as would be collected by human resources or for business to business, California has no exemption for that. Virginia allows a broad exception to things that would be typically collected by HR. Their definition of consumer excludes persons acting in a commercial or employment context. So if you're an individual and it's data that's collected as part of a commercial or employment context, that would not be subject to the privacy laws. And Colorado is similar to Virginia's. The methods of opting out tend to vary. In California, you can opt out of the sale of your personal information and the sharing of your personal information. In Virginia, you can opt out specifically to targeted ads, the sale of personal data, or profiling. And Colorado is the same as Virginia. Sensitive data is treated differently, and sensitive data is generally data that kind of tracks with what we might call a protected classes, race, religion, that sort of data. Is treated slightly differently and is generally more protected. In California, you can request to limit, or you have the right to request limits to the processing of your sensitive data. In Virginia, it requires an affirmative opt-in before the company can process that personal sensitive data, as does Colorado. California does require some rulemakings for regulations for companies to perform risk assessments for sensitive data, for high risk data, or operations that have a high risk of data being breached. Virginia and Colorado both require companies to perform data protection assessments and require that information to be released for oversight. Kind of an appeal process. California has no appellate process. Both Virginia and Colorado, you can appeal if the company, if you request them to make some change and they don't, you can appeal that within the company. And if they again deny it, then you can go to the Attorney General. Virginia requires that the company provide a mechanism for them to directly contact the Attorney General. Colorado just requires that they notify the individual that they can contact the Attorney General. For enforcement, and here we see some significant differences. California has the Attorney General can enforce the act, but they also create a new agency, the California Privacy Protection Agency, that can enforce it. Virginia has the Attorney General's office enforcing it, and Colorado has the Attorney General's, but also any district attorney. California also allows a private right of action. So an individual could enforce it on their own. Virginia and Colorado do not allow for private rights of action and only rely on the Attorney Generals or the district attorneys. There's also in some instances a cure period where a company would be allowed time to fix the issues that they may have. In California, the agency, newly created agency, is permitted to allow that, but it's not required. Virginia has a 30-day cure period. Colorado has a 60-day cure period that expires January 1st, 2025. That's just some of the things that we see that's coming out with how they're handling personal data. I'm happy to provide more information to the committee as needed. That's a question that stands for them.
Questions on this, and it's a huge amount of information really to look at. Even the California bill itself is over 130 pages. The Virginia bill and Colorado bill are significantly trimmed down, which is probably from our perspective and the way we draft an asset of an approach. The Colorado bill, I think, was 32 pages, somewhere in that ballpark. So much more streamlined. One of the things that we've discussed in the past committee is the idea that if we forward substantial amounts of brand new territory in consumer protections, we are not necessarily a big enough economic clout or population stake to have industry just then go back and change their software and change what they do to comply with us. So I think the hope and discussion we had in the digital identity working group in the past has been trying to look to the other legislation, pick the best of that legislation and put something together that provides consumer protections for the state of Wyoming that rely to a large degree on things that have already been championed by the other states, but then make sure that we can implement those in the state of Wyoming and if they're appropriate to the state of Wyoming. So I think that's probably the hope if we draft a piece of legislation is to pick the best of all worlds, but we kind of need to discuss if there's any key concepts or any key provisions that we want to ensure are or are not in a draft that we move forward. And I'd like to have the working group and LSO work on a draft that incorporates these consumer protections and privacy and effectively the self-sovereign identity rights with our digital identity framework, integrate those and basically build off of what we worked on last year to get that done, but wanted to make sure that everybody had an opportunity to kind of see these options and weigh in if there was anything that there was a great deal of concern about. One area that is contentious, and I think we should contemplate, maybe hear public testimony on and discuss, is the private right of action. And the reason for that is in California in particular, they created a whole new agency to enforce this. So they have people that will spend all day, all night working on cases on behalf of their citizens. We're probably not going to be creating a new consumer protection agency in the state of Wyoming. Seems unlikely. Virginia and Colorado rely on their district attorneys and their AG, if I'm not mistaken, as you said, to enforce these laws. I don't know that we have the bandwidth for those entities to go out and provide any real protection either based on their funding levels. So some sort of a private right of action might be appropriate. I don't know exactly what that looks like. And that is an area where in other states, in particular in Colorado and Virginia, when they were working on this, that was a concern from industry, was they didn't want lawsuit after lawsuit after lawsuit hitting them, similar to what we discussed before. So the concept that I'd like to explore is what would a private right of action look like that was thoughtful and had some sort of a reasonable bar, but provided for that private right of action so that our citizens of Wyoming would not have to rely on the overly burdened AG and district attorneys or a new consumer protection agency to enforce that. So honestly, that's something that I'd open up for folks that might have thoughts on it. Mr. Co-Chairman, Chairman Nethercott, Representative Stiff, anyone that has some insight into how that might be drafted in a way that we could provide some balance if you have any ideas, but we can work on it moving forward too, because that was something that I wanted to contemplate. We don't have to go through that now. I think we've got public testimony and some other things, but if that can be on your radar to consider and those that provide testimony, any ideas can be valuable.
Mr. Co-Chair.
Go ahead, Senator.
Thank you, Mr. Co-Chair, and Mr. Hopkinson can certainly but my understanding is the Consumer Protection Act to take action on behalf of a consumer as well as an individual private right of action. So under our consumer protection laws, that concept already exists. So I would just think that could be easily transferred into this type of action as well, if that's what.
Do you know how that's currently structured? I think that sounds accurate, but
Mr. Chairman, my recollection off the top of my head is that Senator Nethercott is correct that we do allow for private cause of action in those limited circumstances that are provided for by statute currently.
So using the same mechanism effectively and expanding some of the rights makes sense. Anyone else have any thoughts on that before we kind of move on to other testimony?
And I think that's the rationale behind this.
That affects many consumers. And so in that circumstance, it's appropriate for the AG's office to step in and act on behalf of all of those potential consumers who were harmed by that commercial bad actor. So similar in this case, where there may be a circumstance where a number of Wyoming citizens would be affected by some of the concerns outlined in these Privacy Act bills, that would be appropriate for the Attorney General to act collectively on behalf of people, as opposed to maybe it happening in an individual circumstance. Not that they wouldn't in that case either, but there is the options available. That's the rationale.
For a bra,
For a bra?
Representative Smith, thoughts?
It's a big topic that requires a lot of thoughtful consideration.
All right, further on that before we go on. Any further questions for Mr. Hopkinson on with that? All right, thank you, Mr. Hopkinson. And with that, I know that Mr. Christopher Allen, who is also a member of the Digital Identity Working Group, would like to provide some thoughts as well. So welcome once again, Mr. Allen. The floor is yours.
Thank you very much. Again, I'm Christopher Allen, Executive Director of Blockchain Commons, a Wyoming domiciled corporation, specifically because of the laws that you have created in the last couple of years. I am not a lawyer. Instead, I'm a technologist. I'm best known as the co-author of the world's most dominant security standard, TLS. That's the HTTPS. The S is for TLS, and it secures trillions of dollars worth of internet commerce. A particular note for this identity session, I am a blockchain architect who wrote 5 years ago the design principles for self-sovereign identity that have guided a global decentralized identity industry. And I am co-inventor and architect of the emerging W3C DID, aka Decentralized Identifier Standard. There is now an extensive ecosystem of standards, specifications, products, companies, and even governments supporting these foundational principles and DID-based technologies. But for self-sovereign identity to truly achieve international success, I feel that it needs to be embraced not just by the technology sector, but also to have a solid basis of law. In our last legislative session, the first legal definition for personal digital identity passed, was signed by Governor Gordon, and now is law. My belief is that with this law and with Wyoming's foundational work to create other legal frameworks for digital assets, the state will be known for its groundbreaking work in the future also for digital identity. So there are two words inside this definition of personal digital identity that form a key part of this law that I think some people are missing. In the law, it says that personal digital identity is defined as the tangible digital representation of, by, and for a natural person over which he has principal authority and through which he intentionally communicates or acts. Now, at first glance, this definition seems short, but it is the subtleties of the term principal authority that give it particular strength. To unpack this, the use of the term principal authority acknowledges the existence of an entity at the heart of a digital identity. And that entity is a natural person with all of their inalienable rights as granted by our Constitution. It also says that this entity, a natural person, has authority over that digital identity. That's packed into that term principal authority. This is also exactly parallel to the first and second principles of self-sovereign identity, which are existence and control. We're capturing it now in this language. But there's a lot more that these two words imply. To start with, because principal authority is drawn from the laws of agency, that means that your authority over your digital identity is delegatable. You can delegate it to others to make use of that in various ways, just like you can delegate a financial advisor to make decisions about your assets on your behalf or help you make decisions about healthcare, legal affairs, et cetera, in the real world. And like those, you have the ultimate control. You have the principal authority to pull those delegated decision-making back to yourself or to give it to others. Now, delegation of digital identity happens all the time when you construct an account on a social media service. The difference under Wyoming law, well, when it's recognized that it's your principal authority that is being used, your delegate must work on behalf, on your benefit. Like a CPA, a lawyer, a doctor, the decisions that they make should be in your interest. And that's also what self-sovereign identity is all about. A digital identity that is controlled by you, that benefits you. That's not what we have today, where social media and other internet sites are using your identity to benefit themselves. The laws of agency also imply that in addition to benefiting you, there also must be customs and duties of care. It is these duties that I believe that are our next steps to define under Wyoming law. What are the customary responsibilities required of a party that you've delegated portions of your digital identity to? I suggest that we can define some of these this year. There needs to be general duties about access and transparency, portability and interoperability, and minimization from possible harm when mistakes are made. There also need to be similar duties to those that are you're giving these agency to, that should be parallel to that for CPAs, lawyers, doctors, other professionals, that they disclose conflict of interest, that they be responsible for reasonable competence, diligence, and care, and that they be transparent about their actions, and that they have fidelity and faithfulness in representing you. Now, I do suggest, because of, as was mentioned before by Co-Chair Rothfuss, that we do need to be looking at how other states are doing things, but I recommend that we leverage and try to figure out how to reframe some of those things under the form of principal authority and the associated laws of identity in the agency law with duties, custom, rather than solely basing them off of commercial and intellectual property law. Because in fact, most privacy violations today are violations of your authority, not just a loss of property. I've included more details about principal authority, some open questions I have, and other suggestions for possible consideration by the legislature in this session. The full article is attached to this meeting minutes, and it's also available on my blog at www.blockchaincommons.com. I also hope that this year the Select Committee can reconsider last year's bill giving special protection for private keys, or at least those that are used in digital identity. For it is the secrecy of these keys that is the link between the real world natural person and their authority online. Thank you again for your time and support for this important emerging issue, and your support of the foundational digital identity law. It's been an honor to be able to contribute to these efforts. Thank you.
Thank you, Mr. Allen. I appreciate that, and really appreciate all of the work and the sort of academic study and bringing together this community that's now been looking at, contemplating, and debating the concepts of principal authority in the context of our digital identity that you've inspired in the last couple of months, which is really fascinating to see, and hopefully the Select Committee's kind of been following that work. It's what I think we hope for in trying to forge digital identity into the foundation for a lot of these privacy and property rights moving forward, and it seems to be taking hold. So we appreciate your efforts in that. Questions for Mr. Allen?
I got a question.
No, hold on. So the way we do public comment, we'll have you come up at some point. I'll recognize when we get to public comment, bring you up at that point in time, and then you'll have the opportunity to ask that and feedback. So it'll be just a couple more minutes, but thank you, and we'll get to you. Anyone in the committee? All right. Thank you, Mr. Allen. We'll bring you back in a little bit, but I will say that the idea of trying to integrate, and if we start with, for example, the Colorado law, which is the most recent, try and take the pieces of it and then integrate it. I think what you said about linking it to principal authority concepts is going to be the key to it and the challenge. So that's what we need to accomplish, and I think that'll take some work, but that's an important part of the path forward. So thank you for raising that.
Thank you.
All right. Thank you, Mr. Allen. Let me see if we had anyone else from the Digital Identity Working Group. So other members of the Digital Identity Working Group, I see Daza out there. Daza, welcome. Any thoughts at this time?
Yes, thank you very much. I'm Daza Greenwood from law.mit.edu. As Senator Rothfuss mentioned, I was a member of the Digital Identity Working Group and also commend the committee and the legislature for enacting the legislation. I had two comments, one related to doing something similar to California Consumer Privacy Act with respect to extending the Digital Identity Act of Wyoming. And then the second one is following up on a topic from the last hearing about other places in existing Wyoming law where the Digital Identity Act could extend. Okay, so with respect to the contemplating something like the California Consumer Privacy Act, CCPA, there's one of the key rights, or two of the key rights afforded consumers one of which was mentioned by by LSO, is deletion of data. The other one that I didn't hear mention of is access to data. When consumers exercise either of those two rights, unlike say do not sell, there's a subset of provisions under the CCPA that provide guidance and some requirements and constraints for companies that will need to additionally verify the identity of those consumers. I think the thinking is that deleting someone's data or accessing their data is particularly important, and depending on the sensitivity of the data, can have significant consequences. So there's, you could look to California Civil Code Section 1798.140 and the California Code of Regulations, Title 11, Section 999.301X for some of the best of that, although the requirements are a little bit sprinkled in different ways through the statute and regulations. The reason I'm bringing this up is because I think if Wyoming were to adopt something like the California Consumer Privacy Act or its or comparable legislation from other states, and were to adopt especially these functional rights to personal data for consumers to have their data deleted or to gain access to their data, you might look at streamlining and simplifying how additional verification of the consumer and their requests could be done by leveraging this concept and these and services that give rise to people using their personal digital identity. And because one of the issues with that's coming up practically with CCPA now is that it's hard to authenticate consumers, and there's very idiosyncratic kind of patchwork of ways that consumers have to authenticate themselves and verify themselves company by company. It tends to dilute, or in some cases thwart, their ability to exercise their rights. And that's because, in part, their identity is fractured across all of these different domains and platforms and businesses and networks. The whole concept of this personal digital identity is that there's a digital identity that arises from the individual, and that can neatly be expressed through things like self-sovereign identity and public-private keys. That's not the only technology that can do that, but the idea is, what if Wyoming were to recognize that businesses subject to a law like this can acknowledge and authenticate a user based on that user's own identity. Okay, so what that would mean is that consumers could basically amortize the effort they put into security on their identity, the passwords and other methods of authentication and securing the credentials and tokens, and be able to use that across all of these different business and legal and technical domains. This could be very helpful. So that's my first comment, just sort of directional comment for legislation and inquiry about the relationship between the identity law that you now have, the Digital Identity Act, and ways to streamline and make more usable something like a CCPA in a Wyoming context. Should I just drive right forward to the other point or pause at this point, Senator Rothfuss?
Any questions for Daz on the first point? All right, seeing none, go ahead.
Great, thank you. So the other point I just wanted to make is there's I think a very relevant section of existing Wyoming law that could benefit from incorporating a reference to the new Wyoming Digital Identity Act, and it is 6-3-902 on unlawful impersonation through electronic means, including some penalties and definitions for that. And in particular, right now, the way the most relevant section reads is a person's guilty of a misdemeanor punishable by a fine or imprisonment or both if he knowingly and without consent intentionally impersonates another person through or on an internet website or by other electronic means included but not limited to spoofing. And so that's a really good start. There's a lot of ways, identity now, especially through this whole constellation of devices and other types of services, and even things that may, in some senses, go through protocols other than HTTP, are still part of our identity, including home networks and other types of networks and transaction networks. Whatever the technology is, whether it's a website or an email or some of the other very specific things that are defined here. And by the way, the statute defines electronic means include an email account or an account or profile transmitted via the internet. It's not bad, but maybe you could look at amending and basically updating the impersonation statute to include impersonation of a person's personal digital identity, partly because the definition of personal digital identity is exactly broad enough to encompass any means, and it doesn't sort of lock you into tools like email and websites. So I've got some back pocket language for potential amendments there, but it may be premature to go into that level of detail. I mostly just wanted to introduce the suggestion of looking at reforming that existing section of Wyoming law to reflect and support the good work on the Digital Identity Act. Thank you.
Excellent, thank you, Desert. Any questions on those points? I do think that's a good idea for us to update that impersonation. That makes good sense, and the language we use, I think, would work very well with that. Anything else? All right, Des, anything further?
No, other than thank you for the opportunity to speak today, and I'm a huge fan of the work of this committee. We're all watching you, and we're very grateful. Thank you.
Excellent, thank you so much, and I think we've got a lot of work ahead on this piece of legislation when we get it drafted, so I look forward to seeing you on some Zoom calls. All right, thank you, and let's see, we've got Brendan signed up from the working group as well, Digital Identity Working Group. Brendan, did you want to weigh in on any of these points as well?
Yes, please. Quickly, my name is Brendan Marr. I'm a MIT Media Laboratory alumnus and computer scientist, and on this working group and several others. Thank you, Senator Rothfuss and committee members. I wanted to go towards the point of the fact that Wyoming is dealing with a whole different slant and a whole different view of digital identity than all of the other states, and really needs to take the opportunity to drive this new architecture of Web 3, which is not Web 2, the old web with clients and servers, and the new Web 3, which is distributed, which is a fundamentally different architecture, and really work towards simplifying the language to deal with the new ways in which individual data will be controlled. The salient nugget to think about is that in the old web, things are controlled by clients and servers, but in this new web, there is the opportunity for data to be encrypted on the device and for users to manage that data and control that data themselves. So as we work towards this, various sorts of legislation and statutes that we're creating across the board with digital identity and e-residency, registered agents, et cetera, and later I'll be speaking further about registered tokens and other things. It's important to take these things into account, that this new architecture is and how people control and manage data is fundamentally different. That's all I have to say.
Excellent. Thank you, Brendan. Appreciate it. Any questions for Mr. Marr? Questions? All right. Seeing none. We have Claire listed, but I don't know if Claire is available or wants to weigh in.
Mr. Chairman, Claire was just going to listen in, and I don't think she has any comments.
All right, Professor Sullivan, raise your hand if you want to say anything. Otherwise, move on. All right, looks like we're clear there. Professor Sullivan is another member of the working group, and I think that does it there. Do we have anyone else online that I'm missing at this time? All right, excellent, thanks. Then let's get to public comment on digital identity and some of these proposals that are here in the chamber. Sir, if you want to come up and join us now and ask that question, you can certainly be the first. And please introduce yourself to the committee. We're the chair. Welcome, and we're happy to have you.
Yes, thank you. My name is Ron Mill. I'm a developer in the Cardano blockchain ecosystem. I'm also a co-founder of Soccer, also the CEO. So my question was to Chris Allen.
And what's the question? We can pull it back up. What is the question? And actually, we typically work through the committee, so you'd ask the committee the question, and then what we'll probably end up doing then is asking Chris Brown.
Sure. So it's two-part. First part is so the sovereign identity that he was talking about is he was talking about having someone work on behalf of the individual that has that identity and he was talking mainly for professional services. How about like parent-child relationship? I mean, is this sovereign identity, is this kind of going to be similar to social security numbers where you get that at birth? Or is this something that you attain yourself as a point of authority? Like when you decide that you want a digital identity. So that was the first part. And then second part was who can control this? So can a parent control this? And then also, so if they are controlling this on someone else's behalf, like their child, can they benefit from anything that their child is getting like throughout their life? So this could be monetary things or other like achievements that they've had in their life.
Well, I can answer briefly, go back to Chris Brown as well, but we had a discussion along these lines when we were drafting it as well as during the legislative session on this legislation. And the first legislation that we moved forward as the framework was very much silent on it in deference to existing statute effectively, where all of those rights and authorities already are clarified. There's case law that clarifies it. And so we were rather pointedly not weighing in and changing anything for that purpose. Now, as we move forward with some of the consumer protections, we might get into places where we start affecting that and changing that. But that was a conscious choice that we made not to make new decisions for a digital identity, which is again a right for that individual and it is from their principal authority. So when you start thinking of a child, as their rights change through their life, then the rights over that principal authority would be going based on, or would be evolving based on those same changes, if that makes sense. That was the way we framed it at the beginning. But I will bring back Mr. Allen to see if he had anything to add on that from the self-sovereign digital identity concepts that he has provided.
Yeah. So the first principle of digital identity is that, digital identity itself is insufficient. There is still that ineffable I and your relationships with all these other parties that is part of you being a natural person. So we always should go back to, parallels in the real world. And I think children and also the elderly are both classic positions of guardianship and things of those nature, which are rather extreme. They're lesser forms of different kinds of powers of attorney, et cetera, that at least, in the case of children is mandated for the natural person who is a child. But, there's limited things that parents can do and authority over the child that they have. And ultimately, when the child turns 18, they can repudiate those or choose not to do those. I think we have to have parallels to that in the digital world. And that does exist. A number of the decentralized identifier platforms are working real hard on issues of guardianship and stewardship and being responsible for those parties and making decisions for them, but also under a framework where if something goes wrong, somebody abuses those powers of attorney, those stewardship, guardianship type things, that ultimately it has to benefit the natural person. So I think we want to parallel that. I think similarly, identity, because it is this ineffable thing, you can't say that there's a singular digital identity. That's just a view of some particular digital authority that you've granted around specific things. And anytime we try to say, well, digital identity is it all, we're making a mistake. So I feel like when I look at say the California laws or things of that nature, where somebody else might go control or that's property, it's owned by the person or other different types of things, I see it instead as that you've basically overridden the authority of the individual to have a say in those things. And so I always try to go back to what is the authority that you have ultimately around these types of things, and how is that expressed, and maybe how that's being violated and how we can stop that violation from happening. I hope that helps.
Absolutely. Thank you, Sean. Ron, do you have any further questions for the committee?
No, and I just wanted to thank Mr. Allen for your work that you've been doing, and appreciate you guys letting me come up here.
Thank you very much. Appreciate your testimony. Any other public comment this time? Please join us. Introduce yourself to the committee and welcome.
Thank you, Mr. Chairman, committee members, for the opportunity. And I just want to make a brief comment in that.
And what's your name?
I'm sorry, Darren Shelton, co-founder of Fuel Trust, which is a good Texas C Corp. And we appreciate the work that y'all are doing here. And that really is at the heart of my comment, because just as you are looking at other states as you consider modifications to your own bills, other states are very much looking at what you're doing. And to that end, linking, if I can, off the comments being made by Mr. Greenwood, Allen, and Mayor, I would encourage you to be as very forward thinking as possible. Because at the heart of anything blockchain is a human, an identity. And whether we talk about decentralized finance or autonomous organizations or cryptocurrencies, they're either owned by or they're a counterparty to all of these things. When we think about privacy, anonymity, pseudonymity, we've got cybersecurity issues. You can go as far as credit histories. Everything is moving so quickly, and at the heart of all of it is going to be digital identity. So thank you for the work you're doing. And I hope, since others are going to copy your playbook, kind of cut and paste, that you will long game it out as far as you can Because I really do feel like the work you're doing here is very much leading the nation in this. So it is a great work, and thank you again.
Thank you very much. I appreciate it. Any questions? No questions? Thank you so much. Appreciate it.
Mr. Co-Chairman, I was just curious what it would take to move that C Corp to Wyoming.
If we can send you the paperwork.
Yeah. I've got my co-founder scoping out properties.
No, thank you. So, thanks so much. Any other public, oh, my apologies.
Applications on the table here, maybe, as we.
Bringing those, yeah, or have a QR code right up there. You can scan it, we domicile. Any further public testimony on digital identity this time? And just to be clear, we will be, please come up and join us. Introduce yourself once again, welcome back. We'll definitely be carrying this over to the next select committee meeting, so there's no urgency to get your comments in here. We'll have legislation to review in November. Welcome back. Reintroduce yourself to the select committee and let us know what you're thinking.
My name is John Stix. I think it was 2 years ago, I won an award at the Wyoming Hackathon for our digital identity proof of concept. And back then, it was kind of like a tongue-in-cheek, kind of like Black Mirror, like, you know, we kind of abstracted it for animals, for dogs, right? The Blockchain Kennel Club was the thing. So like digital identity is kind of one of the most important topics for governance, and it's like when you boil down the definition, governance is essentially the extension of digital identity and what identity represents, the relationships, the assets, associations, and reputation, all those metrics that are associated with it. So these past couple of years, I've been working with this fellow Johan on his invention, pseudonym pairs. You go to pseudonympairs.tech to see a functional smart contract for a population registry. And one of the proof of concepts we want to use for this tech is a state ledger and a national ledger, and ultimately a global ledger because of population registry. And this is a very critical component for, you know, like DAO governance, right? So you want to have one person, one vote. Otherwise, there's no point. Otherwise, you know, psychopaths will take advantage of the power vacuums that are created by the imbalances of the authentication of the proof of personhood. So I guess there's a few definitions that need to be laid out. The proof of personhood and population registries. And then I'm kind of losing my train of thought. I'm really tired, but yeah, essentially that's kind of at the starting point is the population registry. And from there we could build a web of trust using, you know, natural NFTs, you know, tokens that represent reputation metrics. And from there we could build actual true trustless applications, true decentralized applications, but we won't get to that point until we have digital identity. So that's my testimony.
Absolutely, John. Good points. Any questions, John? Go ahead.
Tell me what a reputation token is.
Can
I buy some?
Yeah, can I buy some?
It's not that fungible.
It's not that fungible.
Tokens like don't have a value, and it'd be more like on a permission scope where like certain addresses are whitelisted after in context of that for like when a user is generated an application, they're assigned a vote, and those votes only have a permission to go to again the candidate's address. That candidate's address only has a permission to receive that vote token set. Like simplified concept could be abstracted and applied in different ways.
Representative Stith, any follow up with that?
And that's
I would.
and that's the idea of like a natural non-fungible token, which is like the practical utility of these things beyond like the JPEG stuff y'all are seeing all the hype for.
And a simple use case that we've discussed is we've wanted to be able to tokenize and provide authentication for something like KYC AML for banking, where your digital identity is verified. So that's a credential that digital identity would have authoritatively, and then potentially have it be portable so that you could go to a different institution, a financial institution, and then you have a credential that says, yes, you've been checked by somebody, but you don't have to necessarily be checked again, and you don't have to provide all of the back end information again because you have that credential. So that gets to the this credential about the individual that could be portable. So that it's a great objective. Obviously, we've talked about that a few times. We run into problems with the fact that the Fed don't really want us to do something like that. But we'll get there eventually. That's a concept of that type of credential. Yeah. Further questions for John? Thank you very much. Further public testimony this time. Please come up, join us. And introduce yourself to the committee. Welcome. We appreciate your input.
Thank you. Hi, my name is Autumn Bison. I am the CEO and founder of Ordinal Inc. We aim to establish trust tokens, relationship tokens that represent people's actions in the supply chain. We have immutable self-publishing palettes that are designed to be smart contracts that will act as your e-bill of lading, carrier coverage, and insurance. With this, I'm struggling with the right to be forgotten. Can you help me understand what the right to be forgotten means in this environment?
And for that question, it's a challenge, obviously, with the construct of a blockchain existence and a digital identity. We recognize that it comes from the GDPR, right to be forgotten. And then how do you do that when you have a ledger that doesn't let you be forgotten? There are tech solutions for dynamic information, obviously, that's referenced by the blockchain, but then you can delete the dynamic information that's stored somewhere else, so you can have an addressability that gets you there. But honestly, it's a challenge, and we're looking at that. We know that other states, CCPA includes consideration of that. GDPR flat out did it, said you can be forgotten. But it's a great discussion point that as we contemplate digital identity and what consumer protections we're going to put in place, that it's a sticky point that I've struggled with as well. Right to be forgotten on a blockchain is a challenge. I mean, I can do the official. I've struck it from the blockchain, but that leaves the previous entry in the blockchain as a blockchain entry, right? So you can't really delete. If you have any ideas or any experience on how you've seen it appropriately implemented, we'd love to hear those. Do you have any thoughts?
Short of changing your own name, I don't know. Yeah, so thank you.
Absolutely. Well, the right to be forgotten on that concept is who forgets you. You're not going to be fully forgotten, but if you have an entity and you basically want your records expunged that they have that are dynamic records, that's what GDPR tends to get at. So one of your larger internet service providers, if you say, I'm exercising my right to be forgotten, and that means a full elimination of all of the data that they have that is expungible, that's typically what you exercise through GDPR. And we could emulate that. But when you get to, if I put a picture of you on the blockchain and with your name under it, good luck, right? I think, Mr. Allen, did you have, I see you available, and Mr. Allen is obviously an expert in this space. He's probably thought more about it in his sleeping time than all of us have in our wakeful time. So I'd be interested in hearing his view on that.
Yeah, so this particular area is complex because we conflate identity broadly, and we also often think of it in kind of property terms. So to a certain extent, I don't have a problem with if I want to participate in your system of governance of a supply chain, that I agree that certain kinds of history about my participation in this chain will be shared and cannot be pulled, right? I mean, maybe I'll say that there ought to be some adjudication format where where I can appeal things there. But it's part of my authority is to say, hey, we can enter into these kinds of things together where we both have an interest in the best practices. The problem with a lot of personal identity stuff now is that people did not explicitly grant that authority. and my kind of, that permanence. And my take on it is, if you did not explicitly say this can be permanent, and this permanent's going to benefit me because it's going to be allow for my supply chain to be more efficient and avoid bad actors and all that kind of stuff. So it's going to benefit me to participate in this reputation system. If you don't have something like that, it should be expunged. That's one way to look at this particular thing, but I will absolutely agree it's a thorny issue. Similarly is the proof of personhood, where people want to have one party, one vote, a lot of anti-civil mechanisms, so we don't have computers voting for you. There's a whole active movement, that includes the founder of Ethereum, Vitalik, and many others, to kind of investigate this area, because they're interesting, human rights challenges, because it can also, these same things, which can be very good for certain scenarios, can be very bad in other scenarios. So we have a lot of work to do, but progress is being made. We're articulating this stuff, and we would love to have you and others involved. Thanks.
Thank you, Mr. Allen.
All right, that, thank you for the committee, and thank you.
Absolutely. Thank you. Any questions before speaking to parts? Seeing none, thank you so much. Appreciate your questions. All right, any further public comment at this time on digital identity? And I'll just note, please come up. I'll just note that if you do provide public comment, if you would sign in, even if you hadn't already signed in yet, just so that we've got a spelling of your name, and then we can include that in the minutes, that would be appreciated. Thank you so much. Welcome. Please state your name, introduce yourself, and let us know what your thoughts are.
Storyteller, filmmaker, media entrepreneur. And this is a little off topic, but not really. There's a generation of people right now who already have a pre-existing digital existence. I wouldn't call it an identity, but lots of people are. And it was done through clicking the EULA box on Facebook or wherever. And I'd even say there's a second generation who's now deeper in than that first generation we're witnessing. And what are the implications when you're looking forward a long time now? There's implications there to look at with that next coming generation of people for digital identity. And that's something I'm working on in a project, but it's, we want to let people create a sovereign digital identity from the start. What does that path walk be? Government's allowed to go digging through your Facebook. I mean, there's so many, I'm not looking for answers. I'm just saying this is something that should be thought about deeply, because I know a lot of young people with maybe a shady looking digital identity that's pre-existing already because they were 14 years old on Facebook or Instagram. So anyway, all stuff that should be thought about and considered as you go forward with this concept of what is your digital identity in this new world that will exist possibly virtually and definitely digitally. So
thank you. Was it Mr. Fox?
Yeah, Kevin Fox.
Thank you, Fox. Appreciate it. Questions for Mr. Fox? Go ahead.
Sure.
Yeah.
Thank you, Mr. Chairman. Mr. Fox, so, I'm thinking of an example of trying to figure out, like, where is the line of what makes sense to protect the consumer versus the right of some piece of owner that owns, that has control of a piece of data that represents something that I did, right? So if I post on a message board when I'm 14, and then I want to run for office when I'm 33, should there be a consumer protection to allow me to compel a message board to delete those posts? Is that my data or is that their data? And I think those are the kind of questions that we want to grapple with what does it mean to have consumer privacy protections? And how do I have, does that reflect part of my digital identity, even though I don't have control over it anymore? Should that, or should I have control over it? So those are the kind of questions that I'm interested in. And I'm interested in hearing what the public has to say on that.
Mr. Fox, what are your thoughts? Go ahead.
I know people who can get that message board for you off. Do that. That's a whole separate conversation. But this is what I'm concerned with too. By checking that, did not read EULA box when I was 12, right? I'm with you. How can we protect the future of those kids who did that stupid thing? I wish I had an answer for you. My answer would be absolutely, that has to be getting rid of. That's it's always been your content, but Facebook, Instagram, and others would argue differently. So, and I'm from a media company looking into the new world now, and
well, hopefully, possibly, where are those forms? I think we're setting up, I think we're gonna set up our company here. You know, the idea would be that that has to be your information. And with the smart chain and smart contracts and blockchain, that will be your information. That's our job. Our job is to create an entertainment property. You will contribute, but you own that. That's yours. We don't own it. And that's what this blockchain will absolutely give the opportunity for an audience participating in an entertainment property, which is what Facebook is at the end of the day. I'm watching. Everyone's on their phone looking at Facebook. It's an entertainment property. It's a channel. And it's content generated by people. What? Who owns it? And the reason we're thinking of coming here is because we want to own our intellectual property. And Wyoming allows us to do that. Whereas Warner Brothers in LA wants to buy the intellectual property and do what they want with it. It's user generated content ultimately at the end of the day, most of it. So what will we do? We move into Wyoming. So
Happy to have you.
thank you, everybody. Unless there's any more questions.
Representative Yen, any follow-up? Thank you so much for your testimony. Appreciate it. Any further testimony? Come join us once again, and I see you over there as well. Again, please introduce yourself for those that aren't aware. Welcome back.
Thank you. David Ucci, Silicon Prairie, blockchain kind of development in the space since 2010. I actually have some deep thought in with regards to identity and identity reputation systems. Just as a quick refresh and reminder, we actually have analogs in the real world with regards to retraction. So such as the case is if a newspaper has to run a retraction, they don't run around and pick up all the newspapers that they delivered the previous day, right? We just all agree that going forward, this is the truth, the authoritative system of truth. Noted cryptographer Bruce Schneier said that it might be a generational issue in that eventually everyone will have had some at some reputational event on lastnightsparty.com, right? So to the point with regards to identity and potentially the idea of having a lifespan associated with these, there might be an opportunity for a sunset. There might also be statutes of limitations per se. The real question is whether or not just because the data does exist, whether or not there's action or there's something actionable that can be based on that.
Any questions? Questions? Thank you again. Appreciate that comment. Please join us. Again, it's committee.
My name is Trey Cannon. I'm mostly just a bird dog kind of general researcher in the crypto space. Been involved with a project recently called Governor DAO, which is for the first DAO to be legally recognized in Wyoming. They've come out with the proof of existence token, which uses a biometric algorithm via face scan and voice line that ensures you're one person for anything as far as voting, buying an NFT. My issue here is with all this, with being the right to being forgotten, we have bad actors in the crypto space, lots of bad actors. With this token, if they can't delete this token and go get a new one once they've had it on that account, if they can only deploy smart contracts from the account with the token and they screw up and take money from people they shouldn't be taking, then they can't deploy a contract again without people knowing it's that same bad actor. If they have the right to delete that token then and go get a new one, then we have a problem. As far as like gatekeeping bad actors out of communities. So that's one issue I have. And then the next thing I have is we were like the last gentleman was talking about metadata as far as your whole internet history, everything you've ever done. The problem with the proof of existence, like on the blockchain, is they're totally different. You can't really mesh the two unless you go to like a totalitarian internet login style system. So it's just to me it's just an extremely lofty like goal as far as real consumer protection. Like how do you know that somebody took your data without going to every single website you've ever been and asking them for that data back? You don't. So I don't know. I just feel like all this stuff should be really thought through for many months, and we should. maybe that's the production too, because like what we're seeing right now, like there's a lot of problems with gatekeeping certain individuals, like say you don't like somebody. The whole governor, the whole DAO can get together and just kick you out. And you vote to sell your tokens, like it's just not it's not an easy thing. It's difficult, and I'm starting to get it out. I'm not very prepared, but I hope you'll have comments later on this stuff so I can get a little more concise argument put together. But that's pretty much all I want to get out there. That there could be reasons for disallowing somebody. Like I can't, if I got 3 DUIs, I can't just go get that expunged usually. That's all I have to say. Thanks for your time.
Thank you, Mr. Cannon. Appreciate it. Any questions, Mr. Cannon? Further public comment? Further public comment? Seeing none, public comment is closed. Back to committee, and I think we're going to take a brief break because we've been going for quite a while, even though we are behind schedule. Let's come back and start back up at 4:15. I think we'll probably just talk a little bit about what we want to do for a piece of legislation, have that drafted, discuss more next time. So we don't need to take a lot of action at this point in time. And then we'll do that. We'll get back to e-residency hopefully pretty quickly and then try and get back to our agenda. So we are on break until 4:15. Okay. All right, let's come back to order. So we just concluded and closed public testimony on digital identity. We had some good discussion. And subcommittee, without objection, I think the best approach is to have legislation drafted and probably start with the Colorado legislation, which is the most clean and concise and the newest bill. And then try to wrap around the concepts from the Colorado legislation into existing statute built upon our digital identity definition and legislation from last year. So we're properly accounting for what we've already accomplished in digital identity and kind of contemplating what Christopher Allen was talking about, ensuring that we're not just looking at consumer protections, but these rights go along with the person and their identity. Any objections to that approach and any thoughts on what else we need to contemplate and what else we should add as we start this drafting? We'll continue to cycle it through the working group and have some revisions over time and bring it to the next step. Go ahead, Representative.
Mr. Chairman, I have to finish up my homework, but it's such a big topic. Seems like there are. I guess LSO can do some work on that. I don't know how I'm going to vote on it. I just don't think it's a big topic.
Absolutely, Representative. It certainly is a big topic. We have been contemplating and discussing digital identity for a few years now, trying to really wrap our arms around it for that reason, and figuring out what path to proceed down. Well, we started with the concise legislation last year and then wanted to build and layer these other concepts on it. And we contemplate really how much we want to add and how big of a bite we want to take this year. Obviously, the Colorado legislation that was passed was a lot more concise, and I think the definitions and some of the characteristics are more thoughtful in advance, so they seem like a good foundation. But yeah, if you look at the information that was provided, right, we've got the California Consumer Privacy Act, which is sort of the first of these in the United States, and a lot of it was based on GDPR. We've got the Colorado Act in our materials, and then we've got a comparison that was done by a third party that sort of shows those differences between the two. So I think we've got some information that at least gives us an understanding of what's in it. And in previous conversations and on the working group, a lot of these concepts are built off of the self-sovereign digital identity concepts that Christopher Allen has been advancing. And these are commonly accepted and adopted in the stakeholder community, and they're very much intended to be objective, technology neutral, and that's the intent certainly of, I think, the path that we take going forward. So as we move forward, if it looks like we're going too far or we're going into uncertain territory, then perhaps we can scale back and try and take a smaller step. But I think we need to get something in front of us before we can really have a good conversation about it. Go ahead.
Mr. Chairman, I would add one specific recommendation in the statute to add digital personal identity. Makes a lot of sense to me.
In the say one time, my apologies.
In the spoofing statute, that's why I'm at 6-3-902 to add in after the word person or personal digital identity. I think makes something discrete that makes a lot of sense.
You should incorporate that. Yeah. Please note that. We'll make sure that we're trying to incorporate digital identity concepts into statutes such as the spoofing law.
Mr. Co-Chair,
Go ahead.
that could be a standalone bill, just a quick cleanup, if you will, to the spoofing statute.
Okay. I think there are a few other places where that applies, where there are statutes that personal digital identity could be incorporated. So let's explore that. If we want, would you rather have that as standalone or incorporated into this larger digital identity?
I think it would make sense of a standalone
Okay.
bill.
All right. I'm absolutely comfortable with that. Without objection, anyone have any concerns about having that short bill draft? All right, let's do that. And again, back on the original question, anything else that we should be adding or contemplating or drafting directions as we put together a digital identity bill? Go ahead. Still on this one. Further discussion, seeing none. All right, well, without objection, seeing no objection, we'll go forward with the draft and we'll work on taking the Colorado pieces, work with the working group and building Wyoming specific statute proposal on that. All right. And it sounds like Representative Western would really, really like to make a motion right now that is a little out of order on the agenda, but he wants to, so. Representative Western, did you want to make a motion?
Thank you, Mr. Chairman. I'd like to make a motion for a bill draft in regards to open banking. It's a concept that is quite popular and common in Europe, some of their banking institutions. And I think, given how this committee has been the tip of the spear in innovation, in regards to cryptocurrencies, digital assets, et cetera, I think that is something that really super helpful. And I think taking a crack at it would be really beneficial in the next evolution of digital assets and banking.
All right, so the motion is on a bill draft to create a system that would allow open banking.
Yes, opt-in.
Opt-in for Wyoming charter banks. Is there a second to that?
Yes.
We've got a motion and a second. Discussion, go ahead, Representative Young.
Mr. Chairman, before I vote on this, I'd like to know what that means.
Go ahead, Representative Western, can you provide a little more detail then for Representative Yen on
Mr. Chairman, I think that
draft would do?
absolutely looking at what United Kingdom and some other European countries have done, it could certainly just be a template for LSO for chocolate since it's that kind of small legislation. Absolutely.
Not California.
Go ahead, Mr. Bill.
Suggest that we invite Mr. Lindholm to ask the question. Representative Yen.
And Mr. Chairman, I saw some pained looks from our bank regulators sitting in the back corner as well. And suggested that he also come up and.
I think this is a great idea.
Why not have them both up at the same time?
All right. Would you join us if we won't make you say anything you don't want to? Again. And maybe what we can do to start would be to ask Commissioner Faulkner without any without any commentary, if he could provide us a little bit of background on the concept of open banking and what that means.
Mr. Chairman, Albert Faulkner, Banking Commissioner for the state. It's great to be here and chat with you, even though I wasn't planning on it. In fact, I did my best to dodge it. I've now learned my lesson to not have a private person anymore. But we chatted briefly about this issue. One, I'm wondering how early on my discussion can I start pounding the table? Is there a protocol to that? Oh, okay. It's an interesting concept. It obviously has got more traction in Europe and the UK. And it really, I think, depends upon who you ask if open banking is a good idea or not. I'm not here to say one way or the other. We've not really contemplated it too much. There are a lot of advocates, but it was mandated in the UK, so it's a little bit different approach as opposed to an opt-in. And so then you do start talking about data privacy and those types of things. There's obviously a lot of benefits. I mean, the fintech community can provide services through an open banking environment that gives allows smaller banks to remain competitive. So if you're able to use data, there might be ways to dissuade screen scraping type practices, things of that nature. It can give the consumer control over data, and if you want to utilize a certain service authorize this third party to do something for you on your behalf. I think there's some opportunities there. And our office has been supportive of bank fintech relationships if they're done properly. Obviously, there's a lot of federal guidance out there about how to manage third-party risk because there is a significant amount. Open banking complicates that a little bit because not only do you have a third-party vendor risk management, but you also have data privacy, and so you're blending those two together. Which obviously, why, based on the last hour's discussion or 2 hours discussion, it's a topic of interest. So our only ask is we'll need to look at it to see if there's any. We don't want to get crosswise with federal legislation. Well, I shouldn't say cross. If it's opt-in, it wouldn't matter. And if it somehow if the state were to authorize something that's prohibited at the federal level, we'd have to figure out that dynamic. But that wouldn't be the first time this body's come up with something that the federal level maybe didn't agree with entirely. So not completely outside your wheelhouse, but nevertheless, we can sure engage in the discussion, and it may be a smaller issue or it might be a larger interim issue. I don't know at this point.
And can you briefly just describe, I mean, it actually relates well to digital identity, but can you provide a view of what would change if we allowed open identity relative to what our banks currently can and can't do with data or with anything else?
A little bit, Mr. Chairman. It's really more about if third-party affiliate, there's rules under that in the sharing of information. There's practices that banks can engage in that they have to disclose the activities, what they're doing, the relationship. And disclosures are more around products and services pricing, but there are certain things that they're required to disclose on what they're going to do with your data with an affiliate relationship. Banking as a service is becoming more popular, and so there could be relationships that they would have to disclose. Does open banking, allow that to happen more easily? I don't know, but there's a lot more to it. I'd have to study up on exactly what all the intersections are and what either problems we're solving or potential issues that we may be creating inadvertently.
Are there other states that have enacted open banking style of TMT in the United Kingdom?
Mr. Chairman, not that I know of, but it's a topic. I mean, it's the American Banker always has articles on it. They're definitely contemplating it. You just got to remember that in banking, you have a very strong tie between state and federal banking laws. You just can't separate them. That doesn't mean states can't do things. Obviously, the state charter continues to be the charter of choice in this country to the tune of about 80% of all banks. So states have a lot of authority and responsibility in this area. So being a potential leader is not new to the state system.
And one other question I have, honestly, is just it's hard to contemplate what this would look like statutorily, but we've worked over probably every line of your statutory construct over the past 5 or so years. Do you have a sense of, is this the type of bill that ends up providing a few paragraphs of authorization for an opt-in and then some tweaking? Or is this, let's go back and revisit the entire statutory construct for banking?
Mr. Chairman, good question. I don't know. Where I thought you were going with that is this type of bill that needs to authorize another 10 or 12 employees of my staff. But apparently I misread that. But since I brought that topic up, Bill, no, I don't know yet on that.
And go ahead,
especially slow to understand. So if you had an open banking system, say you're in the UK, you're banking, what kind of information can the bank give or share with other third parties that's not presently allowable here? What's the categories? Is it like my spending patterns in my checking account, or is it something different we're talking about?
Commissioner, go ahead.
I'm not sure. I'm not sure if I can go into the details yet. As I told Mr. McCollum, so there's a lot of things we'll have to study as to what the differences are, and I'm really not prepared at this point to be able to answer that.
All right, we've got some exploration ahead here. Representative again.
Thank you, Mr. Chairman. So I have a lot of questions. First is, do you blame Mr. Lindholm for poaching?
Go ahead, Commissioner Cox. Mr. Chairman, Mr. Land is serving the state well in his current role, but we have an extremely talented general counsel still in-house.
Thank you.
Go ahead.
Mr. Chairman,
Follow-up, Representative.
So ultimately, I'm trying to understand what they have in the UK, and it seems to be, as you said, that they're requiring them to have certain data access for third parties so you can incentivize competition in that space. And so I guess my question is probably similar to Representative Stitz is what can the banks not already do here? And then I guess that question ultimately goes to Representative Western is what would need to actually be in the bill? Or are we talking about a memo on open banking where we can actually just go over the concept and maybe some of what the differences are between the UK bank system and ours?
Mr. Chairman, Representative, again, a good question. Without really doing a deeper dive on it, I'm not quite sure, if it's just a matter of, idea of mandating anything always makes me a little nervous even as a regulator, but how we approach it, if it opens certain things, like I said, if it's an opt-in and maybe it's a front-end authorization that allows for the sharing of information with third parties more efficiently, might be an avenue. I'm just not quite sure yet.
Paul,
Mr. Chairman.
Jeff, we'll get any follow-up for that? Yeah, Representative Western, and then we'll be clear.
No, Mr. Chairman, just to elaborate. First question. I think given the context of this committee, our role in financial innovation, the fact that open banking really is it's a new concept in the US, has been implemented in the States, I think it would be at least a good idea to come up with a bill to really start that conversation and really get that dialogue going, whether it's a finished product, we really run with it, or whether we let it fizzle out at our next meeting. Obviously, we can collectively have that discussion, but I think given the role of fintech within the broader banking system, within the context that we've been talking about with our speed links and whatnot, I think the benefits it has to small banks and the bigger ones alike can really turn the page in the next evolution of fintech technology and how that can benefit consumers and everyone involved in the space. So that's the intent behind it. Sorry.
Representative Foss? Mr. Chairman, yeah, I think I'm still confused because the UK system is a mandate for open APIs. And if we aren't mandating it, I'm not sure and we're just making it an optional thing. I'm not sure what is preventing a bank from just doing that without any statutory permission. And then if we don't need to grant them permission for something, then what would a bill draft do? And, I look at Mr. Hopkinson's time to be well spent. And if he doesn't know exactly what is going to be in the bill draft, I think it would be more appropriate just to have a memo to go over what are the options that we could pursue rather than having a bill draft where we don't know what would be in it.
Thank you, Representative. Again, Mr. Lindholm.
Yeah,
Interested in responding. Sorry for.
Thank you, Mr. Chairman. I think it's a great conversation and it dovetails pretty nicely into the digital identity aspects. Particularly if this committee were ever to try and chase down that KYC AML monkey, because I still think it's probably the most worthwhile go after in regards to digital identity. Clearly I'm biased in that regard because I've been beating that drum for years. When we're talking about regulatory or heavily regulated entities such as banks are, they're not going to move. They're not going to do a dang thing until there's regulatory guidance, and understandably so. I wouldn't move if I were them either. I wouldn't move towards an open API or open banking without regulatory guidance, just because of the risk assessment that comes, especially considering what other states have done in regards to the protection of digital identity or any identity. California and Virginia, for example, are pretty well known for what they've done. And so I do think, to Representative Western's motion, I think that there's merit in going down the trail and looking at it because it is a convoluted scenario where regulatory guidance, I think, would be heavily appreciated by the industry in that case. By making it an opt-in versus a mandate, I appreciate that. And Representative Western's open banking, something that I've looked at quite a bit because I do think there is merit. And I think everybody in this room, Democrat, Republican, Libertarian, Independent, whatever you are, nobody in this room wants to see a mandate where third parties can scrape your information. I think that's important to who we are as a group of people that are all interested in what's happening in this space. And I don't think banks want to do that either. So I think there's merit in going down that road and putting a hard line in the sand saying, you know, if you're going to do this, first of all, you've got to opt into it. We're not going to say that you as a state do it. But second of all, you've got to inform your consumers, your customers, and they've got to opt into it. So I think to expand on Representative Western's point, a double opt-in would be even better instead of making it just as the bank makes that decision for their customers. They do make those types of decisions all the time for their customers. So, you know, probably going to be a tough bill because of the amount of black helicopters that can fly on this type of thing. Because people are sensitive to this discussion. But that being said, it is huge. We're doing our very level best to attract fintech companies. This is right up their alley, number one. And number two, no other state in the nation has tackled this. The federal government hasn't tackled what this looks like in the United States. And I'm of the opinion that it's coming. Much like Commissioner Fortner just spoke to, is the ABA is constantly writing about it. We've seen countries, well-developed countries in the EU mandate. I think it's coming, and I think it would be well served for this committee to take on the challenge of trying to figure out what that looks like in the United States. I don't know whether a memo with options that you can pivot off of and go to is the right idea, or a bill draft is the right idea. I couldn't guess, but I'm excited that you guys are even debating it because I do think there is merit in tackling that and making it an option for banks to be able to diversify their portfolio. Sounds awesome.
I'm not sure if you have this information, but to Representative Yin's question on a memorandum, I think there's really only two models, right? We've been talking about the United Kingdom model, and then open banking exists in developed nations in Latin America, Mexico. Right? So, but I don't know if you have, I don't know if you can speak to the differences between the models. Just as I'm looking at this, it looks like Mexico did theirs through regulation. I don't know that that it was legislated. I don't know if you speak to these different models, but that might get us through the concept of the memorandum.
Go ahead. Yeah, thank you, Mr. Chairman. To my understanding, in the Mexico model is it's relatively the same in regards to a mandate being put down on the banks. So the top end is the most important thing right off the get-go. As far as how it's developed from there on out, I think how it's worded as far as your legislation or a memo, the most concentration that can be put on it in regards to what those privacy protections look like. And the opt-in scenario is going to be the most important part of the piece of legislation. Obviously, this goes into Title 13. But as far as the build out, how a bank operates, something like that, I think that's going to be the shortest part of your bill, and it's going to be a one-line. Third-party APIs are allowed.
Yeah. Right. So that was going to be my follow-up, Mr. Co-Chairman, is that Mexico model mandates that every bank have an API that can interact with fintech institutions and share that data back and forth. And so it's really not that complex of a bill because it's just saying you may have an API to communicate with fintech organizations. And we just have to define the parameters of what data can be shared. And it's generally, we're talking about general information that is, at least in the Mexico model, it's already public information. Right?
Mr. Chairman?
Go ahead.
I think it's more along the lines of defining not what data can be scraped, but more along the lines of how that data can be scraped. I think is the most important part of this whole scenario, and what it looks like, because I think the banks are they're going to adopt, and Commissioner Fortner, correct me if I'm wrong, but their normal operating procedures would, if they develop anything that's outside of their normal purview, they're going to develop a regulatory stance on how and where and why. Whereas I would imagine the legislation would just be enabling in regards to saying go or no.
So in the interest of time, I think we probably need to resolve, we're not making a final decision here at this point in time. There's a few things that are clear. One is, I think this is an important topic that we certainly need to contemplate, have it on the agenda at the next meeting. And so we should note that this will be an agenda item at the next meeting. There's still a lot of confusion and I think background information that's needed by the select committee. So if we can have another one of those one-page memos that doesn't go any longer than 3 pages, because I don't like to spend all of your time on it, Ms. North. But I think that would be invaluable to the committee to understand more about who's doing open banking and what it means, what the implications are. And then getting back to the motion on the table from Representative Wickstrom, motion for a bill draft. I'm fine with that if it's a 2, 3, 4-page bill draft. I'll vote for that. And particularly only if it's double opt-in and looks like the paragraph that says you can use an API that goes in the banking title. If it turns into, upon reflection, and we have to have 100 pages of conforming consideration for some reason, I don't want to support that because we're late enough in the season that we just don't have the bandwidth to do it. So I don't think that'll be the case. I think what Mr. Lindholm said will prove to be true, which is a cleverly placed paragraph and a couple of references to it probably end up being the bill that we can consider.
And Mr.
Go ahead.
Coach, to your point, we can work with David as he begins to dive into it. And if that second scenario, which I don't think is the case, becomes really prevalent right away, we can put brakes on it so we don't waste LSO's time. But I really think it's more of the first scenario. I really don't think you're going to have 100 pages of conforming.
Yeah, I think so too. I'm a little worried about it anyway. Go ahead. Sorry, Senator Furphy, you had your hand up a minute ago and I missed you.
Thank you, Mr. Chairman. Let me explain a couple of things here. First of all, there are national regulations on all banks, as Commissioner Fund. We have to disclose if we disclose any information to a third party, we have to disclose that to the consumer. So all of you get once a year from your bank these 3 pages of stuff that you look at, throw in the trash.
Look at it.
All of that outlines what's going on. Let me give an example of a small bank, what happens, why they provide to an outside third party. Okay, your debit card in your pocket. A lot of the small banks don't produce that debit card themselves. So they've got to provide the consumer information to this outside third company. Now, you can already opt out. Guess what that means? You're not getting a debit card. So I'm just saying there are a lot of regulations out there. And the national banks were not going to impact anyway. State banks are already disclosing a lot of that information. So I just don't want to overkill this situation because it's already been a big issue at the national level. So I pass it. Thank you.
Go ahead, and let's try and be brief because I think we'll talk about this a lot next time.
Real briefly, just to set expectations, Mr. Chairman, and Senator Furphy is absolutely right. There's another piece of it, which is that almost no banks in this country offer APIs at all.
Right.
So that's a big part of the reason why this hasn't happened in the United States, because the technology platforms of the banking system are I'll withhold, I'll keep it nicer, that they don't operate APIs. There's a whole reason why the history of the banking systems has evolved the way that they have and don't involve APIs. But it's also a big reason why our settlement system is really slow in the United States. And until the APIs are widely provided, I think it's not even practical to ask the banks to do this.
All right. Well, with that, any further thoughts? And I guess I'd ask then Representative Western if you'll amend the motion to allow us to bail on the bill draft if it becomes too onerous, then I know I'll be an aye vote at that point.
Chairman, I would consider that a friendly suggestion. And so, yeah, 3, 4, 5 page discussion gets to be the
monster
California
Yeah.
consumer protection information stuff.
Right.
We'll table that one in the spring.
Thank you. All right. Further discussion on it? Further discussion? All right, motion is on the draft. We'll have it as a agenda item and a memo regardless. Motion is on the draft for next time, hopefully a short draft. All those in favor say aye. Aye. Opposed, no? All right. You seconded it. You can't dump now. All right, that motion is carried, and I expect everyone that was involved in that motion to be a part of the drafting consideration, and of course, Commissioner Faulkner and his staff will enthusiastically engage, as we know he always does.
Magically got full for the rest of the year.
That happens. Thank you. All right. Right on time, Mr. Chairman.
Yes.
We were going to duck into e-residency now as an extension of the digital identity. And I think we're gonna have to add this to our agenda as a longer point, but I know that Mr. Christopher Allen has some information to present for us to consider. And then we'll get this on the agenda for next time also, and maybe we can find a short solution statutorily as well. But Mr. Allen, in the interest of time, let's try and keep this concise, but I do appreciate that we've been wanting to talk about this for a while, and I'm sorry that we're running low on time, but the floor is yours, and we appreciate the work you've done here.
Thank you. Okay, so I wanted to talk about Wyoming e-residency and from the context that I think you're almost there, and it's a shame that we haven't gone all the way. So who am I? I'm Christopher Allen, Executive Director of Blockchain Commons. So what is e-residency in general? So it was pioneered in Estonia in 2014. Fundamentally, it allowed non-citizens online access to Estonia government services, but in particular, the ability to register corporations that have EU status. So what are the benefits to somebody doing this e-residency? Well, lower startup costs, minimal fees, but importantly, all available online. I can basically set up banking services for a new company and merchant credit card within about 3 days. The taxation and fees and everything are transparent. And then, particular to Estonia, there's no tax on reinvested profits. I have access to Estonia and EU courts, which can be important in a lot of situations, but also Eurozone business markets and capital. This has been a big reason why a number of organizations have founded there. And then increasingly, you can receive contracts from NGOs, foundations, et cetera, in the Eurozone area. So it's been a real good thing for Estonia and around the world. So as of 2021, they have over 80,000 e-residents. Again, these are not citizens of Estonia. They're around the world that are registered electronically with digital identities. Over 16,000 businesses were registered by those e-residents. Just in 2020, they raised over 17 million euros in tax revenues. and varying estimates of what the economic impact has been since 2014 of over $1 billion. I do believe some of that has to do with synergy with local startups. This has been successful enough that Lithuania started in January their own e-residency program. It's very immature at this point, but people are beginning to sign up there. South Africa, Brazil, Singapore, Thailand, and Japan have all publicly announced that they're going to be offering things in this form. And I've also had discussions with other countries as well as regions like Scotland and Catalan and cities that want to offer some kind of e-residency type of service. So why do we want to have one in Wyoming? Well, you've set the stage. You've got, HB 101 from 2018, 4 years ago, shareholders represented by keys. We've got a corporate file system authorized. We can do stock records on blockchains. We can do all kinds of interesting things to register digital assets under better regimes. We have support for DAOs, and we have definitions for personal and corporate digital identity. So what are our advantages? Well, we're already known as an innovative state for registering corporations, but we're not number one in this area. We could be. Because we have much clearer laws and regulations about the use of blockchain and digital assets, that can be a particular function. And going beyond the kind of, registering of corporations, there are not only corporations, but individuals may want to have direct access to the laws around ownership of digital assets, clarity about custody, bailment, security, entitlements, et cetera, which are benefits under Wyoming law. You have a legal definition for corporate digital identity. You can take advantage of that. We've got the new DAO laws. We've got series corps. And I really feel like once the Wyoming Chancery Court takes off, and if it really does a great job to try to establish some stuff in the digital asset area in law, that it'll become a place where people go to Wyoming first to deal with these types of issues rather than going to Delaware or Estonia. What do we need to do? Well, we need to enable legislation for e-residency. You already have that in place in the basics. I do believe that there's some substantial changes to how registered agents work. It could be that it's a digital registered agent who can offer and maybe needs to offer more services, maybe is able to offer, proof of personhood or other different types of things. Although I could argue that we could completely eliminate registered agents, and because with the sufficient KYC and other things, as other people have talked about, and actually having a proof of personhood and things of that nature, do you have to have a Wyoming resident to be the registered agent for the company if you've got really sufficient information about the representative. You do need to update the corporate contact laws and regs to match what is going on in Estonia. You need to allow people in corps to use and sign docs with the Wyoming government. You've begun to do that with the ability to do legal filings with the Chancery Court, but that needs to be throughout the entire system. Focus on your advantages, your clarity of law in courts, digital corporations. As I've mentioned in previous testimony, harmonize laws on DAOs to allow combined serial corps, benefit LCs, et cetera. Name changes, dissolutions, and whatever should be all automated. But in particular, a lot of this was authorized in the past. In fact, I did a demo that basically showed this functionality that was done by multiple companies in the decentralized identity space 2.5 years ago at one of these sessions. And we still don't have it happening at the Secretary of State. And what I'm worried about is that when it does happen, we'll have minimal support. We need to not just beat Estonia capabilities or Japan or any of these other countries that are beginning to do this. And I honestly think, since it seems like we can't do it internally, looking a little bit closer at how Estonia does it, they have a lot of public-private partnerships there. So in fact, a lot of their operations, which our Secretary of State does, they have basically delegated out to other organizations that have contracts with their equivalent government services to do a lot of the work and functionality for their e-residency. That would mean that the Secretary of State would focus not on operations for all of this type of stuff, but what are the standards? What are the mandates for interoperability? What are the security standards, the non-single point of control or failure things, and partner with others, rather than trying to do it all themselves. So I know we're short on time. This is my contact information. This is something I've been passionate about here in Wyoming for years, and I would love to see it happen. Thank you.
Hey, Mr. Allen, questions for Mr. Allen on e-residence?
Mr. Chairman, Mr. Allen, thank you. I know it's late in the day, but explain to me and walk me through this so that this doesn't become a conduit for dark money. I mean, it sounds like the Panama Papers, right? Your e-residents in Argentina, maybe they've got their human trafficking operation in Southeast Asia, and they funnel their money into Wyoming, and this LLC that with this registered agent who's an e-resident somewhere in Buenos Aires, uses that money to just buy land in Wyoming for cash. And what are the protections to make sure that doesn't happen?
So to be clear, Estonia still has registered agents, which are separate from the e-residency. So you still, engage with any one of a number of electronically enabled registered agents that are able to work with the equivalent of the Secretary of State in Estonia. What this really is about is the commercial party. So every registered agent needs to be able to identify who the parties are, and in particular, they need to be able to have one party that they can contact directly. An e-resident allows for is proof that that person actually is around, that they have keys, that they're contactable. Maybe other kinds of proofs can be presented that they're a natural person for the Dow law, et cetera. So in fact, I believe it allows for more accountability for that party to be the agent and probably a stockholder, unlike a registered agent, to do and perform the different functions of the corporation's principal authority or of individuals' principal authority. I also feel like, again, I haven't explored all of the opportunities, but I feel like there are a lot of people who are going to want to register as e-residents to have access to be able to say, my digital assets are under Wyoming law and have bailment under Wyoming law, et cetera. So there's some mechanics of, how do you do this for a non-Wyoming resident? But I think there are things that Estonia can't do that this would allow for. And yet protect, the other side of the equation is those people who have small investments in, various DAOs or participating in governance activities around public goods or common goods that they want and don't want to be, blackmail, bribed, privacy disrupted, et cetera. Instead, you do have one party that is contactable, provable with keys, can offer various things on behalf of the company because they have a Wyoming e-residency as a personal digital identity. That help?
Follow-up?
Mr. Chairman, no, thank you. I just wrapping my head around this. If it's possible to do this in a way that doesn't lead to just widespread corruption and dark money through the state, then it's worth thinking about perhaps.
Interestingly, a lot of these electronic registrations end up being more authoritative and more easy to monitor, and you can do it dynamically and digitally. So if you put in place appropriate protections, then you can monitor those protections in a way that you can't right now in our existing system. which is why we had what we had a number of years ago, and that we were, featured in the Panama Papers. It's a challenge without the API development and feature set that Mr. Allen was discussing. So I think you could do it badly and have the scenario that you laid out. I think you can do it well and make it very difficult to do that or to engage in that type of scenario in Wyoming. So it all depends on the architect. Go ahead, Mr. Chairman.
Mr. Co-Chairman, yeah, real quick, and I have a question for Mr. Allen, real quick. Estonia froze its 3 years worth of smart card items that were issued, that security breach. So to your point of centralization, that you could do that, they did that. Whether that's right or wrong. Mr. Allen, my question is, what I'm trying to wrap my brain around is some concrete examples of how this would bring capital to Wyoming. And what I think about is the Teton example. I know we could debate the benefit of the billionaire's haven from taxation in Wyoming, but that's what comes to mind, is that if the benefits are to exist outside of Wyoming, but avail themselves of our availment laws, or maybe it's taxation law or whatever it is, how does that bring capital into the state of Wyoming to benefit the people of Wyoming? What are some examples of how that would work?
Go ahead, Mr. Allen.
So there are a number of different, factors in this. I think Wyoming has already made a commitment to be business friendly, to support things like blockchain and other technologies, to encourage innovative businesses to be here, not just the historical resource extraction businesses. I think Wyoming offers a lot of opportunities and synergy with various parties, banks, et cetera. As far as funding, I don't understand all the mechanics of how registering various liens and assets and all those different filings that you need to do, but being able to do those more economically in Wyoming means that Wyoming gets the fees rather than Delaware. So there's some direct taxation fee-based benefits for it. I think you've already seen in the last 5 years of this committee that you're bringing business and people. You brought me. I'm spending a lot more time in Wyoming. I'm currently legally a California resident, and when I can figure out how not to be, despite COVID and all that kind of stuff, I will. So that's what I have on the table. Similarly, Estonia has found the same thing. They've been able to have synergy between these external companies and local, startups in Wyoming. In Estonia, we can expect the same in Wyoming.
Go ahead.
Follow up on that, Mr. Co-Chairman, and thank you for coming to Wyoming. And that is really the end goal for us. And I think, we all may have different goals as policymakers on this committee, so I shouldn't necessarily say that. But for me, that's my end goal. When we say business friendly, that Wyoming's business friendly, that doesn't mean, to me, giving away everything that's in Wyoming to residents wherever in the world so they can avail themselves of what we have in Wyoming. It's bringing their actual business here to Wyoming. So that's what I have a hard time wrapping my head around, is that having business friendly laws, having the right taxation structure, having everything that this committee's put in place is designed to bring those businesses to Wyoming. Yesterday, our cryptocurrency mining conversation was about how we could intercept the miners coming from China, from Texas to Wyoming, not let them reside in Texas and run their business in Texas, but use Wyoming laws. So I'm just having a hard time seeing how if I get an e-residency from name your nation state where I reside, that I'm gonna decide to move my company to Wyoming. Because I would decide to do that based on the existing laws, not based on the fact that I have an e-residency.
Mr. Chairman?
Go ahead. I'm sorry, just maybe a concrete example that would be, if we look at Estonia, maybe you could share with us the population increase, business registration increase, whatever occurred in Estonia since they enacted the residency law that brought people to Estonia.
Go ahead, Mr. Allen.
Yeah, so I do have some statistics on that. I'm trying to find the page, but I think the key thing that I want to say is, the example of, Avanti Bank in Wyoming, who is, not only hiring, talent that is available in Wyoming, but is also, hiring talent all around the world, but, is, headquartered in Wyoming. From an economic standpoint, you're a small state within the context of the world. You are small in the same way that Estonia is small, and being able to allow your residents to interact and work with these different parties to allow the digital nomads to be all over the place and yet be part and connected to Wyoming residents is part of the advantages. I'm trying to find the final numbers. There is a web form from the Estonian services that talks about their benefits, but I wasn't able to find it in those few seconds.
Thank you, Mr. Allen. Any further questions, Mr. Allen? Further questions?
If I may make a comment?
Brendan?
Sure, I don't know if I can get my video on. Oh. Well, okay, I'll just say it. I had to read. Oh, great. I had to read it more than once, twice or three times, to really understand what Christopher Allen was really getting at. You're going to have to do this one way or another, whether you call it a registered agent or you call it e-residency. What this is really getting at is the heart of the problem we talk about incessantly, and I'm going to talk about next, which is perfection of principal authority, right? So even without e-residency as described, any non-US person or entity can form an LLC in America. That's not a problem, right? They can do that now. This is focused around how do you do that in this new environment of registering entities and things and transactions and assets on a blockchain pegged to the United States and specifically Wyoming. And we'll talk about this more, but we're talking about trillions of dollars of all sorts of assets pegged to Wyoming in which they derive revenue from. That's all I have to say.
Thank you very much, Mr. Mark. Appreciate it. Any further comments? Any questions, Mr. Mark? All right, seeing none, let's go to any more on online public comment on this topic? All right, seeing none there, let's go to public comment here in the room. Please join us, Mr. Fox. And again, please reintroduce yourself earlier and welcome back.
No, it's Kevin Fox, our digital identity. No. So I love what they're talking about, obviously. We're considering setting up something that's not extracting resources from we're talking about bringing a business here that's very different. It's a Hollywood-based business here in Wyoming, and that's very exciting to us because of what you guys are doing. Again, future forward thinking. We're talking about building a piece of the metaverse, a virtual world, define sovereign identity through digital identity, all these things. And you guys are leading the country in this right now from what we're investigating in all the other states that are out there. And, hearing about Estonia, the one thing you offer the most that I think is exciting is there's not even the slightest possibility of a Soviet invasion. Hello, that would change everything, wouldn't it? In Estonia, imagine being there and all of a sudden, boom, well, we're safe here. Please do this. This would be awesome. Thank you.
Thank you, appreciate the input. Any questions, Mr. Fox? Seeing none, thank you, sir.
Never blocked Soviet. No.
Cheyenne.
Any further discussion, any public comment on e-residency? All right, seeing none, public comment is closed. Committee, I don't know that we have any action right now. I think this is something we need to continue. And I think we probably want it on the agenda next time and try and figure out how we can actually proceed with this. I personally love the vision of trying to get us to the point where we have sufficient APIs, capacity, and meet a lot of the standards that Mr. Allen lays out that would make us this central point and nexus for these activities. But
May Sept, Mr. Co-Chairman, created the agency.
Wouldn't that be popular? A nice new agency. Is that a motion? Doesn't sound like one. All right. So we'll keep that on the agenda and try and figure out some action items that we can actually get done between now and then, as well as in the next legislative session. And look forward to working with you more on that, Mr. Allen. Appreciate it. All right, and right on the schedule is the 3:30 non-fungible tokens discussion. Those of you that are still awake and staying with us, we appreciate it. We had, I think, some interesting working discussion. We've got some presentations to bring forward, and we are going to try and expedite a little bit. This again will probably come back on the next agenda item, and boy, I wish we had more time for it. But we've got a few folks that I'd like to invite to come up and join us that we've asked to come here today. Let's start with Mr. Pope and Mr. Kramcha. Come on up, and I know Mr. Pope has been looking into this. Oh, is Dr. Smith with?
Are you with Dr. Smith?
Yes. Dr. Smith, please join us.
Yep.
And then I know Brendan, we're gonna hear from you in a bit also. Well, this is certainly a topic that has exploded nicely in recent months, and hope you want to tell us what your thoughts are, and again, let's try to keep things brief, recognizing we'll bring this back, but where are we and what are you contemplating on at these?
Chairman, thank you. Some would question the wisdom if everyone's tired of having an accountant speak at the end of the day. And now you have two.
Perfect.
Here, and I'd like to introduce Dr. Sean Stein-Smith. He's from the Wall Street Blockchain Alliance. He's also with an associate professor with Lehman College back east. And he is here as part of the FinCon tomorrow, and he and I have worked together on the accounting working group for a couple of years now for the Blockchain Alliance. So first off, I'd like to start off by making sure everyone remembers that as Wyoming goes in this whole field, the world goes. And we continue to be at the forefront, and we want to stay there. We have especially Texas nipping at our heels at this point, and I think that what I'm going to recommend will keep us and help keep us ahead. So then we look at sort of the reasons why I got into all of this. I got into this because I wanted to see an increased free flow of assets unencumbered by intermediaries, where we lower costs, increase speed, and remove barriers to entry. My goal is to have everyone be able to take advantage of what this revolution offers. And that's why I've spoken
several times before, especially on real estate tokenization. I've moved a little bit beyond that, just into the more general realm of NFTs, because I think some of what's required for real estate tokenization can be achieved through NFTs and through some of what I am going to recommend. And this recommendation, especially Representative Stith will absolutely love, I'm sure. What I'd like to do is create a system by which we give personhood to tokens. Legal personhood, which is right now we offer to limited liability companies, corporations, trusts, other nonprofits, other entity types, and I'd like to create that same ability for tokens. If we do that, then a token can be on a title, and I'll leave it to the technologists in the room, or people like Brendan Marr, to be able to tell us how that part will work. But if we create personhood for tokens, then that accomplishes a couple of things. Representative Olson is concerned about how that will benefit Wyoming. It will anchor the token in Wyoming for purposes of collection of annual fees, all of that. And the token and whatever the token owns will be an asset considered in Wyoming. So that is a benefit to Wyoming. It will increase property values in Wyoming if the token is pegged and owns real estate. So my suggestion would be to create a new entity type, which is a registered token. It can be a limited liability entity type. It can be an unlimited liability entity type patterned after the Deutsche ULC, or again, it can have limited liability protection. For my purposes, I don't care, because the token itself can be owned by an entity that has limited liability protection. It, in the beginning, will have limited use. And by the way, I'd like to also suggest that it be added to the type of entity that can be created around our Series LLC entity type as well, because then you would be able to create an unlimited number of tokens underneath. So the last time we talked, when there were a lot of questions about if a token owned real estate, how would you know who the owner is? How would you know who to go to if there were an issue that required condemnation, or if there were ministerial issues? A token would be governed just like an LLC with a registered agent. The registered agent would be responsible for knowing who the beneficial owner is, or at least a representative for the beneficial owner, which would be a lot more difficult in this case than what a traditional registered agent does. But as we spoke about last time, there are companies like Chainalysis and Miracle Science out of UK who will be speaking tomorrow, by the way, anybody that wants to come and listen, that can provide KYC services, provide that knowledge at any one time of who owns the token. The registered agent would provide a municipality or a county with the ability to serve that registered agent on behalf of the beneficial owner. And it answers all of the questions that were asked in the previous testimony I gave, which, by the way, was remotely, and I am so happy to be back live. So thank you for this. I have a lot of notes, but it is late. I am an accountant. I can't really make it that interesting for people. So I'm going to go ahead and either take questions, or we can let Dr. Smith speak, or Rich, or we can
move on. So let's take questions real quick and then we will go in that order. And I see Mr. Revelle has questions. Go ahead.
Chairman, thank you. So, if I understand it correctly, a token owned by a Wyoming LLC, a Wyoming individual held in custody in Wyoming by a Wyoming custodian or held in a Wyoming trust, all those same benefits that you described would be attributed to that token. Am I not mistaken in that understanding? Or am I mistaken in that understanding, or is that correct?
A token, yes, thank you, Mr. Chairman. A token cannot be on a title
For property, any property.
right now as an entity type, as a legal person within Wyoming. It can hold property and hold title. The other interesting part of that is then it can be owned and it can own. And it can be traded electronically and provide all of the benefits that as far as the free flow of assets that I mentioned before.
Thank you, Mr. Chairman. Thank you for that clarification, Mr. Pope. But doesn't the, I guess where I'm going is the right thing here to do to change the definition of a token, or is it to tokenize those things that can possess and are already Wyoming entities, such as now? I mean, should we just tokenize a Wyoming LLC as opposed to creating a token that looks like an LLC? Does it make sense what I'm asking?
Yeah, that's exactly what I was trying to explore. Go ahead.
Okay, so you have the ability to tokenize ownership of an LLC, and an LLC can own property, but you run into significant issues if you then want to do something like a 1031 exchange. The 1031 exchange requires that there be a very close relationship between the owner and the property. An electronically traded token that can, if all of the other rules are met, that can take advantage of 1031 exchange possibilities, becomes a very powerful tool. And that's one of the things I am working toward. That's why the token would have to be on the title. In my estimation, and Dr. Smith can probably speak to it as well as I can, or probably better than I can, if the IRS would view a token that is constructed as an entity type that can be on the title as a completely disregarded non-entity. Therefore, the owner of that token would be able to trade property as if they owned it directly. That's providing that benefit.
So, Mr. Pope, briefly, and then I'll get to finish this. 1031 land exchange, you are a CPA, not everyone here is. So it probably wouldn't hurt to provide a little background on the tax implications of that exchange.
Section 1031 provides that if you trade property for like-kind property, and it is a tax-free transaction or a tax-deferred transaction. You defer any gain until you finally sell the property for tax down the road. And it also provides for a third-party intermediary that can be the go-between, so that you can actually sell your property, buy someone else's property, as long as it goes through and meets the requirements through the intermediary. It can be that it can be considered an exchange under 1031. Am I missing anything, Dr. Smith?
I don't believe so, David. I'll correct you later, though.
Okay.
All right. Follow up. Representative Stitt, did you want on point real quick, or should I go back to follow up? Okay.
Thank you.
Go ahead.
Thank you, Mr. Chairman. Thank you for that clarification, Mr. Pope. So The benefit, as I understand it, is that if a token is effectively the owner of real estate as opposed to an LLC or a trust, then the IRS would treat that as eligible for a 1031 exchange. That's what you're suggesting.
You can structure trust ownership and LLC ownership to be able to take advantage of Section 1031. But the token itself, which is what we are looking at here, is what I very much like to be able to see traded electronically, traded freely, the way it's all intended to on the blockchain.
Thank you, Mr. Chairman. Is that not possible with tokenized LLCs?
When you have a tokenized LLC, an LLC cannot trade its interests under Section 1031 and have it be tax deferred. So the interest would, the LLC itself could sell property and go through the 1031 process on that property on behalf of all of its members. But if a member doesn't want that treatment and wants to cash out, that's not possible. Same thing with a corporation, corporation naturally because it's a completely different, but it is, especially in an LLC, problematic to do a 1031 exchange when not all of the members want 1031 treatment.
Go ahead, Paul.
And is there not a risk that if we redefine tokens in the way you're suggesting that it would have the identical treatment under the IRS's view?
Thank you, Mr. Chairman. No, because the IRS provides check the box treatment, which means that you can choose the treatment of your entity. With a token structured in this method, especially without, if it was created without limited liability protection, the IRS would very probably not view it as a separate entity at all.
As person.
Right, if there's no liability protection, not unlike a European ULC.
Mr. Chairman, I wanted to, and maybe I don't understand tokens. Can multiple people own the same token? And if so, then don't you have the same issue like Mr. Rebel was saying?
Mr. Chairman, yes, you would. If you have multiple people owning the same token, or if an LLC owns a token, you would have the same issue. The issue that the defining factor here is that the token can be electronically traded. It actually is on the title so that that it can avail itself of Section 1031. And yes, one can be owned by multiple people, and you can further potentially subdivide that token into 1 million equal parts underneath. Probably not available immediately in Wyoming because that would require a systems change to the Secretary of State because of the fact that they don't have an API right now. And boy, I wish they did.
Andy,
you guys should discuss that at some point.
Thank you, Ms. Pope. Further questions? Representative Stiff, Ms. Long?
Thank you, Mr. Chairman. I really like this idea because of what we talked about earlier this morning, where it's really hard to make what's happening in this technology backwards compatible with existing legal concepts. And so just creating new ones actually solves a lot of that problem. But one of the questions for Mr. Pope, I've had this thought about making protocols, giving protocols personhood, right? Because you worked on the Series LLC bill, and a lot of open source protocols pre-blockchain used Series LLCs, where the open source community contributed or formed a Series LLC, and then each license that used it hung in a different Series LLC, so that you have the parent owning the software and then all the different licensees hanging in series off the parent. So this is really interesting, and I just sort of curious if you've thought about that, giving the protocols personhood, legal personhood, as opposed to giving the tokens issued under the protocols legal personhood.
Long, that is a capital idea. I think it is wonderful. The question, and I think Mr. Nacho, Mr. Moore later on, there will probably be questions for them about what actually goes on the legal title, whether it is for real estate, heavy machinery, autos, whatever. If a token is going, or a protocol is going to own a piece of real world property, what goes on the title? And I believe this legislation, if we were to create it, could define this area such that it could conceivably be a protocol or an actual enumerated token.
Sloan, follow? Yeah, good. Other questions? Go ahead, Mr. Butcher.
Mr. Pope, I'm not an accountant, but I want to go back to the conversation about the 1031. And if I understood you right, and there's probably more to it, but because the LLC is treated as a disregarded entity by the IRS, a disregarded entity doesn't get to use the 1031 exchange. Is it because it's disregarded? Because an S corp and a C corp can use a 1031 exchange, correct? So is it not as simple as an LLC electing a C corp or S corp status with the IRS?
Okay, I'm going to actually let Dr. Smith talk about this, but in brief, I'm going to say that a disregarded entity can use a 1031. I'm sorry if I made everyone have the perception that I was saying it couldn't. When you have an LLC that is a multiple owner LLC, that's where the issue is, and it's not a disregarded entity under the IRS rules. You are correct. An S corp can avail itself of Section 1031, and so can an LLC that is multi-owner, disregarded. But in any scenario where the entity has the ability or has multiple owners, that entity has to make that election for all owners. Dr. Smith?
Dr. Smith, please introduce yourself and welcome to the committee, and give us a little bit of background on this and anything else.
Okay, afternoon, and I do want to just open with a quick little anecdote here. I have been closely following the actions of the task force and now the permanent committee, I would say since about 2017. And so I am always interested in all of the ongoings here. And so I'm very happy to be here talking to all of you in person, face to face. So in terms of the background on me, I'm on the faculty at a college that's part of the CU NY network, which is, I believe, the largest public university network in the US, serving over 200,000 students in all 5 boroughs in NYC. So all of that out of the way. In terms of adding any extra commentary on this issue, to hone in on the questions around 1031, one, the issue isn't whether the actual entity itself, right, the LLC, member managed LLC, S corp, or a traditional corporation can do it. It all comes down to add on to whether or not any of the members included under that LLC charter want to in turn cash out. And so in terms of trying to make it easier, trying to improve the process here, the main upside here is that by trying to connect directly the actual ownership of the underlying asset to an individual who then in turn has to be registered, ideally the owner of the token with the Wyoming Secretary of State's office, does in turn have to then also be in compliance with any KYC, AML, and any other methods to ID actual owners. So in terms of tax compliance and any other enforcement measures, having that bright line connecting the asset to the token itself to the actual owner is a main upside here. But I've been here and I actually came here today at about 1:45 p.m. And so the whole afternoon here today has been a conversation basically around tokens, right? Basically on tokens, how to use tokens to improve the idea of a self-sovereign ID, how to protect intellectual property. And so while our conversation right here, right now has unfortunately honed in around corporate tax accounting, which I know is awfully interesting to all of you. The actual issue here goes really far beyond only real property, right? And it honestly hones in around how can we build a legal and compliance and confirmation transactional system to keep up with all of the other applications being out on the blockchain. All of you know, obviously, how quickly the whole blockchain crypto space moves. And the conversation around NFTs, basically trying to create a digital ID that is transparent, traceable, and unable to be hacked is really, I believe, based on my own conversations, research, and interactions with individuals way more advanced than I am in this area, is that trying to make tokens, trying to make different crypto assets fit into current legal and compliance frameworks is that next step going forward. And to just sort of wrap up my own comments here before I answer any questions out there, there are just a few other upsides here. Again, honing in on the corporate tax side here. Sorry about that. But in terms of actual market valuation, custody, and actually being able to trace who owns what. I know there were conversations earlier about how can we keep a e-residency basically from becoming a conduit for dark money. If you have to tether your ownership, right, of a real asset to a token, and then that token has to be registered and be in full compliance with KYC, AML, all the rest, that problem is actually solved prior to it actually starting. And to just wrap up my own commentary here, again, I'm happy to be here and I'm so excited about all of these really interesting conversations going on here today. I talk to a lot of people. David knows I talk a lot, talk to a ton of people. And honestly, the ongoing debates here today have been among probably the most comprehensive ones that I've heard so far. Thank you.
Yeah, go ahead, Joel. Questions?
Thank you, Mr. Chairman. Thank you both for this. Does the process by which you are tokenizing the real estate, doesn't then it just become a security?
So off the top, I would not hazard to guess what is or what isn't a security these days. But I would say that simply by tokenizing the ownership of an asset, I would argue, is not going to automatically make it a equivalent to a security.
Paul?
Thank you, Mr. Chairman. And Dr. Smith, I'm not going to hazard to guess what a security is. But this anchors the property to Wyoming. Wyoming has purview over regulation of property, and it becomes a much more solid case that in any review by the SEC that this is a Wyoming transaction.
Mr. Kaufman? Hi. I was curious also about the same thing with regard to transition point, and we all know that we struggle with it, and everybody struggles with this all across the country right now. People are struggling with security on tokens. But as we contemplate, obviously, if you had effectively one owner behind the token and it's a piece of real property, I think we're probably all safe in agreeing, and even if we're an LLC at that point, and you represented ownership of the LLC. With the token, LLC owns the property. You've got 1, 2, or 3, we'll say owners of the LLC or members of that LLC, everything's fine. Is there any bright line that you see or any clear guidance or transition point at which you'd start feeling nervous when we start dividing ownership of that token that owns the LLC or represents the LLC, or even if we directly abstract to a person?
Yeah, well, so thank you, Mr. Chairman. And I certainly don't know that I have the full answer to this, but off the top of my head, there's a couple of different ways that assets become securities under the Howey test. The factor of the Howey test that most often gets focused on is that efforts of others factor, right? So under that analysis, you could have an LLC with 2 people in it, with 3 people in it, right? And if there's non-participating members, by definition, those non-participating members own securities, right? And so that's the whole Howey investment contract analysis that gets thrown around a lot in the context of tokens. A lot of it focuses on that very analysis. What does the efforts of others look like? And so I'm not convinced that we could easily give a one-size-fits-all answer to this context, right? Just because we sort of lower that ownership from the entity level to this token level, right? And so therefore it's automatically not a security. It may well be a security. It might not be, but that's only one piece of it. The other piece of it is how it's marketed and how it's transferred and how it's offered. Because you might have an asset that is a limited liability partnership that owns some real estate, but it's being marketed, right, to investors or others. You can turn it into a security just by way of the offering as well. So that's a long-winded answer of saying maybe.
That's a good maybe. That's a great maybe. Go ahead, Mr. Pope.
Thank you, Mr. Chairman. And for my purposes, I'm not sure I care if it's a security, if it meets all of my my criteria, free flow, as unencumbered as possible by intermediaries, all of that. If we have to, or if the company or whoever is if Senator Driscoll is tokenizing his land in Wyoming, if he has to meet securities tests and get go under some either an exemption or an offering, that for me isn't as big of a deal because it'll be individualized by situation. If you've got a Manhattan office building that is going to have 1 million owners at $10,000 each or whatever, probably going to be a security. But then the return on that, the ability to freely trade and to have 1031 available and all of that, that outweighs the fact that they're going to have to go to the SEC and go through an offering. So to Mr. Lovell's point, yes, probably some of them will be, probably some of them won't. But that's not, in my mind, the determining factor as to whether or not we should do this.
Mr. Chairman, thank you. Just in 2 follow-up questions, and forgive me if this was already brought up, but one, can you give some examples of the other problems that we're solving aside from the 1031 problem with this? I'm just curious about other applications that this might be useful for.
Go ahead. Thank you, Mr. Chairman. Right now, there is a big issue, I guess, with if you own a token, what do you own? And if you own tokenized real estate, what do you own? A lot of people who own tokenized real estate think they own real estate, but when really what they own is a net interest in real estate, in a real estate company or in a company that owns real estate. This solves that issue. It clearly defines that you have ownership and title to that. And the other issues that it solves, really, I hesitate to bring this up because it is real estate specific, and I don't actually mean this to be only real estate that we're talking about. But how long does it take to close on a piece of property? How long does it take to, what has to happen? If you have a piece of property that's on a blockchain that has gone through the process of transference, title insurance, all of that, and then it's tokenized in this manner, then you can trade it freely. That's the biggest problem that I see that this solves.
Thanks. Go ahead and follow up.
Thank you, Mr. Chairman. And just one other general question, because I don't know the answer to this. Have you looked at whether or not this definition could fit in within the property statutes? Because we obviously have some very finite ways that real estate can be held, right? I mean, there's tenants by the entirety, which is husband and wife, or there's tenancy in common, joint tenancy. But there's relatively finite number of ways that real property can be titled. And so I'm just curious if this plugs into that.
Yes, actually, we had a great conversation about this, either the last session or the last committee meeting that I testified to, or the one prior. And that's why I modified my approach to giving legal personhood to the tokens. It doesn't fit very well. We looked at it. I believe the LSO took a look at it and said, and it was having a token owned property. If it is not, it can't do so if it doesn't have legal personhood. Second issue is that that if a token has legal personhood, it can do all of the above talked about. It can create a tenancy in common relationship, be part of a tenancy in common relationship. It can be part of joint interest. It can be part of any of the ways in which property is held, because it can actually be on the title at that point.
Any follow-up? Yeah, go ahead.
My concern with that is that I think if we were starting with a blank slate, everything on the blockchain, sure, we can transact real estate like that, reconcile transactions start to finish. But given how title is a pretty messy concept, I mean, it can take weeks, months, years to do a title cleanse on some property, depending on the nature of it. Don't even get me started on minerals. I mean, that's well, gas companies spend millions a year just on title work. So I think incorporating all that, each state has very distinct statutes around title and ownership and all that stuff, and none of them are the same. County clerk and recorders, some are better than others. Well, I think it's generally good, obviously. I'll keep it to Wyoming. So I think that's a really, I mean, I love the idea. And I think Wall Street would love that idea too. I think it's just to do it and do it right. It's just deeply nebulous and complicated. The two just matter.
Go ahead.
Chairman, I am so excited that you asked. Let's look at the process.
If an LLC buys a piece of property, an LLC has legal personhood, which is what I'm talking about. You go through the same process that you do as an individual. You go to a title company, get a title commitment, get title insurance, and they close on the property. Once that's done, you can have 1 million transactions underneath and buying and selling the interest in that real estate, or I'm sorry, the interest in that LLC, and never have to go through that title process again. If a token has legal personhood, you go through the same process that first time, you have title insurance, then the token if it's traded or any of its subparts are traded, then you don't have to go through that process again, unless you want to. It becomes elective at that point, in which, depending upon the property, depending upon the value of the transaction and all of that, they may want to. But once that token has legal personhood, it's covered under that transaction. So yes, title is messy, but once it goes on the blockchain at that point, it is as secure as any time you and I buy property.
Go ahead, Paul.
Sure. In theory, I agree. But then in that scenario, it places all the more emphasis on, having really good lawyers do all your title work for you. And it doesn't necessarily guarantee that the darn title defects hit somewhere in chain of ownership.
I can shed some light on some of this.
And
Mr.
are you telling me that when I bought my house last year that that there's no guarantee that I actually own it?
Mr. Chairman, if there are gaps in ownership or defects, it's not entirely out of the question.
Those won't go away. No. And they never do. It just essentially makes the ongoing title work and stuff like that elective. And it gives a lot more freedom to the purchaser and seller, and it can provide all of those benefits or not if it is chosen for if someone chooses not to avail themselves of those.
All right, in the interest of time, and Mr. Bob will come back to you in a few moments as we get to comment on non-fungible tokens. I want to get back to Dr. Smith briefly to see if you have anything to add before we go to Rich.
You said no.
Okay. Rich, I know you're doing some interesting work right now in non-fungible tokens, different from what we're talking about, again, exploring this topic. And a lot of what we're doing is trying to figure out if there are any barriers that we're creating that we can bring down. Innovation, like Bob was talking about, where we can do things perhaps a little bit differently to facilitate this dynamically evolving marketplace. So the floor is yours, Rich.
Thank you, Mr. Chairman and members. As you know, the last time I was here, I really left with three things. That you would carefully consider the regulatory regime, that you would describe whatever specifics that the legalities are without a technology interrupt or connected to a specific technology, and that you would deeply consider interoperability. And the world we live in today is very, very different than it was when title searches were started and so forth. And so to Member Long's point, she makes an excellent point about trying to fit everything into old laws instead of creating some new ones and new ways of doing business. That's really what innovation is, right? It's taking old things and reusing them in a new way. So that's really the definition of innovation. And so we have the opportunity to be innovative around non-fungible tokens. And really the proposal that Mr. Pope brings out is actually foundational or fundamental to ownership. And it goes hand in hand with the discussions around DIDs and non-fungible tokens, even to the DAO legislations that are going on and being talked about. If you think about all of the work that you've done, as I'm sitting here, I'm looking at how different the faces of your computers are decorated, right? And you can easily turn that into a token asset, right? But then even deeper than that, you all are here creating laws that other people are leveraging. And so the whole copyright issue comes into play. What if that law was a token and anyone using that law would have to recognize legally where it came from, the work of this body? right? So there's all kinds of ways to be thinking about this, and having personhood for a token makes a lot of sense in a lot of different ways, right? When you start thinking about the implications. But it really has to be something that's a simple protocol that's built into statute. It has to be something from a level that doesn't consider all of the different blockchains and their peculiarities, but could be used by all the blockchains with their own peculiarities. It becomes a real big metadata issue, right? And clearly, you know, Secretary of State and all that stuff aside, there has to be ways to define all of these things in a way that are transferable between, as Representative Western mentioned, different states, different entities or areas of the world see things a little bit differently and they document them differently. So consideration for all of that has to be taken into play. Now, when I testified, I was here talking about several different things. As you guys know, I am the founder of several Wyoming entities, and right now I'm the president of SDK Co. And our work is really about principal authority and creating an operating system that respects the privacy of individuals. And so we think heavily about the DID solutions, and those really are an NFT of sorts. And so the idea of giving a token an identity of its own, a legal identity, becomes very interesting, right? And then you have organizations, like who really belongs to this Wyoming organization of people who are interested party, and how did they sign in to become a member of this group of people who are thinking in the same way? So have you thought about creating a NFT or an organizational token that people can participate in some way? Just throwing some wild ideas out there for you to think about, because it goes to this whole idea of what is it that you view as a legal entity and a legal individual. And with that, go into anything further because it's 6 o'clock.
Sounds great. Thank you. Any questions for Rich? Really appreciate that. Questions for Rich? Thank you. And all strong points, obviously, as we do this work and considering what appropriate governance is and how to recognize NFTs, trying to come up with that legal construct for direct ownership and representation, and do it obviously technology neutral. You know, that's been a priority we've always had and implemented our key concepts. But I think there are an awful lot of challenges to getting this right, because this will be one where we're copied. And I really appreciate your engagement now as well in the space. And thank you. We build this working group and kind of start brainstorming on approaches. We appreciate you engaging. Further questions? All right, and yep, I see Mr. Allen up there, and we've got Mr. Mara first, so we need to go to the video screen. Brendan, welcome. I know you've got a comment at least on one of the recent points, but also may have some other NFT related thoughts. But remember, we are at 6 o'clock, so. Yeah.
Yes, can everyone hear me?
Yes, we can.
Oh. Great, I'll try to be to the point. My name is Brendan Marr. I'm an MIT Media Laboratory alumnus from 95 to 98. And I've been involved in the MIT computational law ecosystems. And I want to actually go after the long game here and really go after Mr. Lindholm's bucket of monkeys. So how did we actually get started with all this? And for myself personally, it goes back to around 2018 when Daz and I created a group called the Automated and Autonomous Legal Entities Group, which was for the purpose of getting 35 lawyers globally, leaks, lawyers and geeks around the world to figure out how to peg DAOs to a jurisdiction. And we spent a number of months. This whole story has not been told, but it was a number of month effort in which we tried to figure out how to peg DAOs to a jurisdiction. And in that process, what we learned were basically how do financial institutions such as credit card companies be able to bridge these different ecosystems of law. And there's a model for this. It is how the credit card companies do this. And this is how we stumbled upon these ideas of principal authority. And a lot of that background went into the formation and support for the Digital Identity Act with the group here in Wyoming and Carla Reyes and all these other ideas. That being said, how did we end up in real estate if we're talking about NFTs? And there's a reason for this. When we talk about NFTs are fundamentally about ownership. They're about ownership of art, they're about ownership of digital stuff, intangible stuff, but they're also about ownership of physical stuff, because you can have NFTs that point to physical assets. So the space is very, very large. And it turns out that this idea of a registered token hits upon all these things that we've been talking about in Wyoming in terms of agency relationships, personal data, registered agents, series LLCs, e-residencies, DAOs that are algorithmically controlled, the Court of Chancery and validation, et cetera, et cetera. But really, we need to take a step back. And it's really, really important because we need to understand first, why is this such a hard problem? Why for years and years and years and years, nobody has ever solved it? And it has to do with some very good reasons. And it goes back to some basics. The basics are that there's a difference between common law and civil law. Right? Civil law in Europe is very different. There's a direct ownership of assets, more or less. Okay, in English common law, there's an indirect ownership of assets, and this plays out in what we have here. So when we're looking at NFTs, we ran into this problem, which is around indirect ownership, which plays itself out in the idea of how do you record ownership. And as David Pope had mentioned, and others, that you can have that recorded as a record of holder or a title. It can also be through a contract, right? But to make things even more complicated, that's just showing ownership. But then there's this whole other thing which comes out of the whole civil law and common law abstractions, is that rights are also separate. So that's a third thing, right? So there's ownership recorded in two different ways, and then there's rights, which are entirely separate. You can have a conference badge, and a conference badge can be ownership of going into the conference, and which are separate rights. Okay, so these are the basics, bases of some of the things that we were looking at. But it's important to also understand that fundamentally what we're talking about is this large problem that we circulate around, go around in circles like buzzards out in the prairie, which is around what we've done with the Digital Identity Act. And that is coming up with this language for principal authority. And the question is, how do you demonstrate, how do you show, how do you prove, how do you validate principal authority? So really, when we talk about a registered token, what we're talking about is ways to be able to demonstrate and peg assets to Wyoming. And this is all assets, basically all assets that are physical, tangible, intangible, real, virtual, all of it. Being able to peg those to Wyoming. And there's another aspect of this, another really, really important facet, which is very, very important to understand, which is this whole idea of, in this new world, how do we actually show and demonstrate ownership, right? So, there's all these metaphors that we can use, but fundamentally in this new world of blockchains and in the old world, there's these ideas of cryptographic signing. Now, we are fortunate to have Christopher Allen with us, who came up with the protocols for the S in HTTPS and SSTL protocols. But what that is underneath the hood is a whole bunch of cryptographically signed certificates that are going back and forth between clients and servers. So this is nothing new. This is how the internet works now, Web 2, okay? But the problem is when we move into this new world of blockchains, there is also this signing cryptographically of transactions, but it occurs differently because you don't have certificates going back and forth, these X509 certificates. And that's due to the fact that each blockchain signs transactions differently, right? And this is the whole idea of a wallet signing a transaction, and that conforms to how things are signed. So really, the old way of doing identity, which is pegged to a jurisdiction, does not work in the new way. And it doesn't work because there's no peg, okay? Because ultimately, when you talk about Web 2, that peg comes from the fact that somebody somewhere has put their physical address into some database, whether it's some company that owns a .com name or whatever, or it's that you have an email address which is bound to Apple or Google, but somewhere along the line in the chain, there is a peg to a jurisdiction. So really what we're talking about here is how to solve the pegging problem. And there are ways in which we can go towards doing that. And I have some also a hint of some statute language which goes towards that. But fundamentally, it is very important to know that you're not going to solve this problem of ownership unless you have the ability to have agency. And this is a really subtle point. And I did skip this, and it's extraordinarily important. We spent an hour and a half this morning talking about the insurance agency, insurance industry rather. And the problem with ownership in a common law country or jurisdiction is that you don't only have ownership of stuff, okay? You also have this idea of agency. You have all different kinds of agents, which dynamically get inserted into the equation of all this, and that changes the legal outcome of events, right? So we have all sorts of agents, right? We have agents that deal with registered agents and brokers, and we have advisors, we have trustees, we're looking at data trusts, we have validators, we have miners, we have software service providers. We've had a number of experts talking about stock transfer agents, all kinds of third-party custodians. There's escrow agents, IP holding agents, real estate agents, financial advisors. I mean, the list goes on and on. And what you have in all of this is the fact that you have ownership, as Christopher Allen and David Pope and many other people have expressed, that is dynamic, that gets transferred over dynamically based on either the dynamics of a contract or the dynamics of a title or other types of events. And we will never ever solve the ownership problem in the United States unless we're able to solve the pegging problem. And
That's
go ahead.
let's sum up real quickly because I think we're all probably ready to go eat some dinner pretty soon and we've still got some motions ahead. So final thoughts before we go to Mr. Allen?
My final thought is we need to kick this can down the road and we need to explore it much deeper because it is far bigger than real estate. It has to do with everything we're talking about.
Thank you very much, Brendan. And Christopher Allen, quickly, please.
Yep. So thank you. I think the main thing that I wanted to share with you is that there are some opportunities technologically that really also have some impact on this thinking. In particular, something called object capability, which forget what that word is. What it really is tokenized authority. And you actually have this all the time in the sense that you have a key that opens up your house, but you may also have a key that only allows the doors to be opened or only allows someone to open the glove box. I think people have seen those types of keys. There is virtual versions of this thing where I can have a limited authority to say, take an action, but then I can sub-delegate that authority as a token to somebody else. I mean, this can be used everything. I could maybe buy a subscription to that a wonderful ski resort in Teton, where I basically buy, a year worth of skiing, but I'm not going to be using it next week because, I'm in Washington, D.C. I can, basically tokenize my authority to be able to use that ski resort and sell it at the market rate, which happened to be really high because it was a snowy weekend. These are the kinds of things where we're able to tokenize authority to take different types of actions that I feel like in many ways are a little bit easier than the harder problem of how do we tokenize things like real property and non-digital things. What we do is we tokenize the right to be able to transfer, or things of, we do that type of stuff is a powerful solution space. That's it.
Thank you, Christopher, appreciate it. Any questions? Committee? Seeing none, quick, Rich.
Mr. Chairman, I would suggest that this group appoint people that can go off and kick this thing down the road and get some good people on it.
Absolutely. I think that's certainly an order of working group. We had some interest specifically for an NFT working group, and we know we've got other participants. So make sure that we organize that. We haven't gotten that together yet, and I appreciate all the input. All right. Thank you all. Any incredibly brief public comments on NFTs?
Yes.
Come on up, is that you? Please join us. Introduce yourself.
It's general comments, right?
What's that?
It's general comments.
We're not on general yet. We're still on NFTs specifically. So you're up next. Okay. NFTs?
NFTs.
All right. And let's keep it quick because you can see
Yes,
we've all
this
sort
is
of.
just a couple of quick points. I am Mark James Mullins. I reside in Casper. And I'm curious if any blockchains have been considered for this NFT to reside on, or does the state plan to create its own through the university or such? Has that been considered yet?
Well, the answer to that is that we are always technology neutral and we don't really prescribe any details along the lines of what you're suggesting. So any NFT work that's done, we want to make sure that we weren't picking winners or losers in blockchain space.
Also, due to the Section 1031 concerns that Mr. Pope brought up earlier, will the token be created with any multi-signature capabilities? Just to ensure that all the parties that happen to be aboard would be in agreement. It would be more of an immutable way of determining the resolution of it.
And just on that one, if we were to create a property NFT token, I again don't think we would necessarily have to be providing specificity as to the multi-sig algorithms that we've used. It would be my expectation that if you were utilizing a token that was representing multiple ownership, that you would hopefully take into consideration appropriate technology for multi-sig representation. But that would really go into the the forging of it with a DAO as we have now or with an LLC, that those expectations would be certainly put in the articles of incorporation or the member agreements that would be implemented in smart contracts. I would expect similar construct, but we obviously don't know or have that yet. Again, in keeping with the theme of how we operate, we try to be hands off and make sure that something appropriately accounted for membership interests, but.
Absolutely. It was good. It was actually getting some insight. Thank you very much, Mr. Chairman.
Absolutely. Thank you for your birthday.
Mhm.
Right. On NFTs, all right, come on up and you'll be next. Again, nice and brief, and we appreciate your cooperation. And don't forget to introduce yourself.
Hi, Anita Chambers, CEO of Ojalair. Very proud to next month be a 10-year, celebrating our 10th year as a Wyoming LLC. When the gentlemen were just talking up here, I do not purport to be an expert on this, but in my head, I heard a completely different use case than real estate for the registered token. And that is, as a serial entrepreneur myself, having the responsibility of raising funds for startup companies, one of the biggest issues that you face in getting people to invest is that they really have no way to sell their interest in the company or their stock in the company until the company either goes public or has some kind of exit event. It seems to me that what they were describing, if the company were owned, if the LLC as an example were owned by a registered token, you would automatically give every investor a mechanism for trading or selling off their investment from day one. I would think that would be a huge advantage to having your LLC in Wyoming, if you could do that, and no one else could.
You can already do that in Wyoming, and that was through statutes probably 3, maybe 4 years ago. That was one of the first things that we clearly provided for, was what are effectively shares or ownership rights or interests in whether it's an LLC or a corporation through blockchain representation or tokenization. And Mr. Kaufman has a lot of experience in this space.
Corporations, not LLCs.
For corporations, but you can own an LLC through.
No prohibition against it, yeah.
Yeah, but you're right. We're explicit on the stock, whether it's certificated or non-certificated stock. So that's allowable. The challenge that people have experienced is almost immediately when you do that, you do get yourself into securities considerations. And so that's where it would be wonderful if it were as easy as what you said, and we wished it would be, and regrettably it becomes rather challenging, but Mr. Kaufman does have a good bit of experience in this space. And we also worked on some reform of some intrastate crowdfunding, which provides fewer restrictions, and passed legislation this last year to improve that statutorily so that the fundraising is at least a little easier if it's in-state and only in-state. The fungibility though, Mr. Kaufman, what about that? If I want to be transferring among the participants in that fundraising, does that risk SEC concerns, or if it's intrastate transfer, am I okay under the WINS?
So, Mr. Chairman, the intrastate securities regulation doesn't really make a distinction. So in other words, I think if you have a share and I have a share and we're, right, that's not regulated, but the method of offering again is regulated.
I see. Okay, so we could do that exchange under our WIN program effectively.
Yes.
But if you went out and then started making an offering, that could get us into SEC. Okay.
Again, just a thought.
No,
Thank
thank you very much. Appreciate it. Come on up and join us. And please introduce yourself to the committee. Welcome.
Good evening, committee. My name is Matthew Elias. Exponential Business Technologies. I'm an attorney. I'm also a co-founder of Dwellfi Incorporated. And our mission is to decentralize real estate ownership. Just wanted to thank the committee for your resolute dedication to these issues. Obviously shows that. And I've followed your work for a very long time, so thank you. I'm just up here briefly to reiterate what Mr. Pope proposed. I think it's a fantastic proposal, giving personhood to tokens and these NFTs, I think it solves a lot of problems that we see in the NFT space now. And I think we all realize that there's a lot of sort of latent potential in NFTs. We see the green frogs, the animated cats, and the pet rocks trading for exorbitant prices. But obviously, we can bring sort of all these real world assets onto the blockchain, and I think it could be a tremendous boon for Wyoming. And I can personally attest that we would domicile and register a boatload of properties in the state if you were to pursue this path. So I'm just encouraging the committee to move forward on this. And yeah, I think it's a fantastic proposal that Mr. Pope has laid out.
Excellent.
Thank you.
Thank you. Any questions? All right, thank you so much for your testimony. Appreciate it. Any further public comment specifically on NFTs at this time? Being none, public comment on NFTs is closed. Back to the committee on that. Any action that we want to take, any requests to staff on NFTs at this time, or do we really want to explore more? And if we do want to explore, are there any questions that we could have for staff at this time, or we can certainly work that by email if we have anything? Before we move on, I think this might be an email follow-up of maybe some questions for staff. Yeah, okay. Without objection, we'll do that, and we'll kind of work that out moving forward. All right. Then with that, we are to that order of business on general public comment. Please come join us. And this is again the free for all for the committee. Please introduce yourself to the committee. Let's try and keep it concise because I don't want everyone to just fade away from low blood sugar.
My name is Augusto and I represent technology providers and we work a lot with DAOs. I think first of all, I second the last comment of thanks everyone for leading the charge on this. And the question is, some of our DAO clients are trying to figure out if they have some files in the blockchain or smart contracts, what is the legal precedence versus something that is not in the blockchain, just regular documents. That's it. And
I would start off by saying always consult your attorney and go directly to your knowledgeable legal counselor. So I'm speaking as a chemical engineer. But you'll see in the statutory construction that, and we talked about this a little bit earlier today, that there is a prioritization when there is conflict between different levels of your hierarchy. So your articles of organization. But what it comes down to is that smart contract, the language that we have, is going to, in terms of the conflict, have priority over basically anything else up the ladder as we drafted it, recognizing that it's going to be what is continuously in action. So if it were doing something wrong, so to speak, conflicting, remember we have other constructs of statute. We're trying to strengthen those moving forward that would require you have the ability to amend those. And what we were contemplating is if you push go on the smart contract, it has to have priority because it's doing something. And so really that was what we were thinking through. It's making things happen. And if somehow things were happening and something else had a higher priority, it would be incredibly challenging to legally unwind that. So we basically just kind of said is, if the algorithm is running and you don't like it, okay, the algorithm is running and you don't like it. So that was the best we came up with. And if anyone has any other input or there's a better way to do it, we'd love to have more feedback on the DAO legislation, but that was the discussion that led to the way we drafted it. I hope that clarifies.
yeah, we do have an idea, but it's for another day. Let's go dinner.
Excellent. Thank you. Absolutely. Thank you, Gusto. Appreciate it.
Your legal analysis was sound.
Was I accurate for a chemical engineer?
We just know you're not an attorney because you didn't charge for it.
Right. I built nothing. And if you want, yeah, never mind. All right. Further public comment. This is general public comment. Any further general public comment? Seeing none, public comment is closed. Back to the committee, and we certainly are short on time, but we need directives to staff if we have any other motions, requests. The only thing that I wanted to contemplate as a possible motion, we don't have to do this now, we can do it later, we can explore it more. We had a lot of discussion yesterday about the idea of the industrial power campus concept and whether we want to draft some legislation for consideration at the next session I've given more thought to it. I've talked to staff about it. And I think the easiest way, and when I say easiest, I don't mean easy, but I think it's the easiest way, would be to allow for the designation of a specific zone that would basically be fundamentally deregulated. It would be outside of the regulated space. I don't even know whether we're allowed to do that, honestly. What? It wouldn't have to be an industrial park, but this would be the industrial park campus. And industrial parks would be outside of industrial siting, but wouldn't necessarily be the equivalent. Although that's exactly what you would expect to designate, right? That's what you'd want to draw a circle around and designate. That's one concept I have. Yep, Mr. Bell.
Thank you, Mr. Chairman. If you're off the grid, are you deregulated?
If you are operating as your own operator, you are not regulated. If you're using the power for your own internal supply, you start to try and sell it, then all of a sudden you start falling into regulated consideration.
What if there is a partnership of some sort, public, private, or otherwise, that is set up, that is closed loop?
So
That is a campus.
there is some allowance for the campus side. This is where we would want to provide a clear, there is no regulation and you would allow that. In statute right now, it doesn't seem like it should be complex, but it is complex. And we actually passed some legislation a couple of years ago that tries to provide some over the fence rights where you can have a partnership, for example, with a coal-fired power plant that is otherwise being terminated. We passed that 2 years ago, but it was sort of specific. So it's a hodgepodge where it probably shouldn't be. So the idea here, potentially, if we wanted to have our industrial power campus, would be to do our best to create a designated area. And the question then is who designates. So that takes into consideration. But once designated, it would be deregulated. And you could have providers all compete for the opportunity to provide power and potentially try and get yourself decoupled from the regulatory costs of power transmission, assuming that you could provide direct transmission, something along those lines. Best I got. Yep, go ahead, Representative.
Mr. Chairman, I'm generally supportive of trying to do a concept like that. In your version of it, is it deregulated to the extent that if they have this campus next door to the Bridger power plant, that Rocky Mountain Power can just say, hey, you're deregulated, we don't feel like selling power to you.
Yeah, I think, first of all, that would be worked out. It would be an awkward placement for that type of consideration. If you are deregulated, though, it probably would be bidirectionally deregulated. It's a good question. Go ahead.
Mr. Co-Chairman, I would ask LSO to provide us current similar statutory frameworks as a starting place, because I think probably this already exists. That's brilliant. It's really not a new concept in many ways. I think it is an industrial park, probably. But with maybe tweaked a little bit, recognizing some uniqueness associated with this purpose. Of course, we're going to call it industrial power campus because that's amazing.
Right.
But I do think that we'll just pull in some of the industrial park statutes for the deregulation associated with it. You know, one thing I want to be mindful of as we talk about a deregulated space is, you know, we heard state trust lands, right? So does that look differently on state trust lands, right? And any of those pieces, it probably should. Understanding that there the space is not ours. So I think that'd be helpful, and we could easily take what currently exists in statute probably and modify it accordingly. I know it's our last meeting, so we're kind of
For November, yeah.
out of luck, but
Well, let's explore it. If it lends itself to a good piece of legislation, we can try and put that together. If it doesn't, then it doesn't. Go ahead, Senator Costa.
I might be stepping clear out on a limb, and if it breaks, okay, let me know. Does this have any implications on the zoning and planning in counties, and is that going to be stepping on toes?
So it is, and that gets back to how you authorize such a thing. And one reasonable way to authorize it would actually be for a county to submit an application to, I'm being totally arbitrary here, SLIB, but at least they look at things like that. So if a county says to SLIB, we want a deregulated zone here, SLIB should then do the due diligence and say, hey, PSC, check this out. Does this cause problems for the ratepayers, cause problems for state's interests? If no, okay, then we go back to the county and we say fine. So that would give the opportunity then for continuity with the county planning and local planning, I think is possible mechanism. That, again, just the way that I thought it through. All right, so let's just hand wavingly proceed. If everyone is okay with that. All right, hands are waved. We will proceed. All right, that's all I had as far as end of game asks. Anyone else have any requests? This is when we'd be doing it.
Open source Secretary of State.
Let's look at that for next time, yeah.
Yeah.
All right, and with that then, let's go to staff and see some summary and some questions, where we are and what we're doing.
Chairman, just to go over these done, and then I have a couple of questions. So we're going to be putting the Uniform Law Commission's UCC Article 12 discussion on the agenda. Also, we'll be preparing a comparison between that article and Wyoming law. We voted to sponsor the lottery amendments bill. I did want to clarify, do you want to specify which house that'll go to now, or just do that later?
We'll do that later.
Amended the Dow bill, and we'll carry that forward to the next meeting. With the amendments. Committee requested LSO draft a Chancery Court amendment bill, essentially addressing that issue with the rules of the Chancery Court. We requested to draft a bill on digital identity privacy issues based on the Colorado privacy law and framing that within the digital identity statute. We requested to draft a bill adding digital identity into the spoofing statute. We requested a memorandum on open banking. Draft a bill on open banking, so long as it's only going to be a certain, maybe if it's too much of an issue. Yeah, well, it's easy down the road.
Yeah.
Committee requested to have e-residency on the agenda for next time. And then we requested to look into, or have LSO look into current statutory frameworks with respect to providing an industrial power campus and deregulation, and look into that and potentially draft a bill on that. So kind of dive in and see where that's at. One question on the deregulation, we were specifically just looking at deregulating related to power generation. Is that?
Yes, for this legislation, and if we have any further ideas, we could contemplate that, but this is definitely emphasizing power.
Chairman, I think those were the actions of the committee.
I think that's what we heard. Anything that we missed, committee? Insurance sandbox, moving that forward to the next meeting. I don't know if that was on the list, make the changes and move that down the road.
Yeah, my eyeballs just skipped over that line, but yes, that's on there.
Good catch. All right, anything further? The final kind of item for business, Ms. Long, anything that you'd like to say from the perspective of the Hackathon Blockchain Stampede? Any announcements to those listening at home or here present?
Thank you, Mr. Chairman. Tomorrow starts the 3 parallel conferences, LawCon, FinCon, and DevCon. And we've got some serious luminaries coming in, including some of the people who've been here with us today. Also, Friday is Dow Day. And Vitalik Buterin himself is, unfortunately, he shared he can't make it in person, but he will be speaking live to us. And then the hackathon itself, the software competition, kicks off Friday night and runs through Sunday.
Excellent.
It's going to be a great show.
Hope you're all able to stay for it, participate as much as you can. and select committee as well. Everyone's invited to everything, so please show up. All right, any final comments? All right, with that, thanks everybody for participating. Mr. Co-Chairman, any final thoughts?
Just want to say, you know, I think we talk about this a lot, but when we started this adventure years ago, I remember we would go back to the legislature and we would have to tell them how many people were showing up to these meetings, trying to impress upon them that it's real. We had our first global meeting in Jackson where we had people all over. And that's before we had the Stampede, and now we've got people from all over the world here for the Stampede. And I just think we don't have to tell our colleagues anymore that it's real. So just really appreciate all of you being here. You're what make it real for us. And we appreciate